I double dog dare you.
Ma'am, you can't sue the baby.
This case is horrible.
The promiscuous defecation kind of speaks for itself.
Hey everyone, and welcome. I just want to thank everyone for your support throughout the past year. It has been unique, and the obstacles that have been overcome are monumentous, to say the least. You all have been amazing, and I am very humbled to have such a fantastic community that have stuck with me through everything that this year has thrown at us. So, to show my appreciation, I am giving you 24 hours to commemorate the shit show production that was 2024 in mostly never seen before. I mean, other than the original airing, which most people didn't see, except for those 3 people who watched it live. Court cases from the past year. I have opened the vault and dug in deep, and I am going across the country and pulling cases from every court that I can find and giving you a little clip from every judge that I can find. Some will be interesting, some won't, but it's a big compilation. It's a court salad of everything. A little bit of everything we have. It's real, it's raw, it's unedited. There may be some oopsies, there may be some things that shouldn't be there, but it is how it was originally aired, and it is all for you. Raw, uncut, unfiltered, unchanged, unedited. Just straight up court. It is what it is. Enjoy it, and I hope you have a fabulous 2025.
I swear or affirm you will truthfully and accurately interpret the conversation in court and defense day?
I do.
Ask.
No, this isn't his.
Oh.
The next one's his.
Okay, so Gilberto Santiago can speak English?
Yeah.
I like that. Good. All right. Santiago, you're fully court charged with child neglect. Can I charge?
You understand your charge?
Yes, Your Honor.
I understand you've been given copies of paperwork and advised of your rights. That's true?
Yes, Your Honor.
All right, sir. Based on your application, I find that you do qualify for the services of the public defender's office. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, Your Honor.
Deputy, criminal history?
11, dealing and stolen, unarmed and unoccupied burglary, unarmed, and battery and 9.
What'd you like to tell me, sir? You want to say anything?
Yes.
What'd you like to tell me?
My name Moses was some pastor. His family attends my church, and I know we call him Tito. I know him for more than 10 years.
Okay.
Good kid all his life. Like to see if there's any possibilities that he's not in my responsibility.
No. Not with a prior criminal history and being in a position of authority over juveniles. No. But I will set a monetary bond. No contact with alleged victims. Court date's going to be October the 31st at 9 o'clock.
What was the bond that broke up?
15.
Thank you. Step to your right to the T. When the green light comes on, sign, sir, if you'll give us a moment. It's just your right. He should add that apple butter with them cattail biscuits.
Right. No, honey or syrup.
Apple butter.
Yeah, I wish my wife could make them. It'd be nice.
They don't know how to make the biscuits?
She don't know how to make the biscuits. Her mother makes the biscuits. Her mother's mother made the biscuits. My wife can't make the biscuits.
I'm gonna tell her what you said.
I'll say it to her. Y'all act like I don't. It's been 32 years. I say this stuff to her face. She don't care. All right. Ask him to say his full name for me.
Dígale su nombre completo al juez.
Eric Alberto Antunes Aguiriano.
He's before the court charged domestic violence battery and simple battery.
Está frente al juez acusado de agresión doméstica y de agresión simple.
I understand he's been given copies of paperwork and advised of his rights.
Entiendo que se le dio copia del papeleo y se le notificaron sus derechos.
Based on his application, I find that he does qualify. I'm going to go ahead and appoint the public defender to represent him.
Según su solicitud, determino que califica y le asigno al abogado de oficio para que lo represente.
Deputy, criminal history?
No, no history, no social to track him.
Bond said it's 5,000 domestic, 2,500 on the simple.
Bien, la fianza son $5,000 en la agresión doméstica, $2,500 en la agresión simple.
No contact directly, indirectly, or through a third party to alleged victims.
No puede tener ningún contacto ni indirecta, ni directa, ni por medio de una tercera persona con las supuestas víctimas.
Court date is September the 20th at 8:30.
Su audiencia va a ser el 20 de septiembre a las 8:30.
Buena suerte.
Gracias.
Thank you.
Is that all you got, Your Honor?
I believe so, Your Honor. Yes.
Thank you, sir. Appreciate you.
Thank you, Your Honor.
Mr. Making moonshine, sir? In the toilet?
Come on.
Moonshine eggs?
What's wrong? Hello? Stand on X? How do I-
Yes, sir. State your name.
Right. Hold on, let me get on the X right way. It's hard to stand on the X because you got 2 feet, 2 directions. Oh, let's do it the right way. There we go. On the X. My name is.
I've been saying that for years. It's hard to expect someone to stand on an X. Wouldn't a square be more?
A square would be like, okay, on the square, like, because in the square, like, I'm like,
Right.
hold on. I'm on the X, as I was trained to, like, a 10-foot bench. What's this?
Mr. Gillis, if I had
Yes, sir.
a dollar every time I thought that we should have something other than an X on the floor, I'd be a rich man.
Well, I'll try and make you a rich man, sir. If I were a rich man, you know, it's my favorite song. Because I used to play, I did Fiddler on the Roof in middle school. Hopefully they still have the videotapes of the DVDs of it. It was awkward. I was up on stage, like, you know, shaking my arms and stuff. Like, I can't do it in the cups, but like, maybe I can do it with my legs. If I were a rich man.
I don't do that because I don't want you to fall.
I won't fall. Trust me. If I fall,
I don't want your pants to fall.
It's paperwork, Mr. Gillis. It's a lot of paperwork.
It's a
If you
lot of
fall,
paperwork.
and then she gets grouchy, and then I got to deal with her grouchy.
Oh, my mom. Right, yeah, I forgot. She's a real grouch. I have a question. Can you look up to see is there actually a restraining order against the house at Tyndall Drive where I used to live, or my mom said she has? I was never served papers.
I don't have that in front of me. No, sir, Mr. Gillis.
Okay, because she keeps calling me and like hanging out with me. It's like something's freaking goofy.
That
I have
sounds
a
good.
question. If I was Mickey and my wife was fucking goofy, could I divorce her?
Him. He's the guy.
Hell no, you can't divorce anyone anymore.
Which is fine. Which is fine.
Wrong Catholics.
It's a very
Lie. Deny.
Okay.
Sir, is there
Well,
enough
Mr.
laughing
Gillis,
gas behind that for you?
you're making it lively anyway. Mr. Gillis, before the court, charged with indecent exposure. You understand that charge?
Sir?
You understand what you're charged with?
Yes, sir, I do.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
That is true.
Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. So you have an attorney now.
Thank you.
That's who you need to talk to about the facts of your case, okay?
All right, thank you.
All right, Deputy, criminal history, Mr. Gillis?
He's actually on probation with you.
With me? Why do you say it like
Professional
that?
probation services.
Yeah. I heard of them.
Is this a violation of probation?
It is.
Okay, so I'm held without bond then, correct?
In just a second, you will be.
All right, thank you, God. Oh, whoa, I was passed
Now
out.
see, I'm gonna go sit you back down.
Too much happiness makes you pass out. Hey, did you know you can buy happiness at a pharmacy? Yeah, so you want to hear a joke, sir?
No, not right now. I'll see
Yes,
you.
sir.
I'll see you at your VIP hearing though, and you can tell me all the
Okay.
jokes.
All right, just remember about the pharmacist.
Okay.
You'll see him next week.
Oh, wait, I'm supposed to be on the X.
Stay on the X. Don't move.
On the X, sir. Yes, sir.
All right, 2,500 on the indecent exposure. Court date's going to be September 20th at 8:30, and I'm signing the violation of probation warrant in case 24-1644. Good luck, Mr.
Yes, sir.
Gillis.
Thank you very much, sir.
All right, you can step out, Mr. Gillis. We'll bring it to you. If you don't,
Yes, I go down.
go back over there. We'll get your paperwork.
Don't dance. Don't dance.
Huh? Going down. Okay, I don't care. If you want to, go ahead. Next.
Stand, bro. Stand, bro. Stand, bro. Stand, bro. What happened?
Yeah.
What was that?
Listen, I was the sugar. I was the sugar.
I've never seen you speechless. All
Because
right.
why he's happy like that, you have to keep him in that mood.
You're right.
Because
No, I
generally
know.
speaking, it's a use of force.
Yes, and it switches fast. That's a big man. All right. For the court charge of burglary of instructor, advance on arm, grand theft of a firearm, and possession of weapon or ammo by convicted felon. Do you understand those charges?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Based on your application, if I do qualify, I'm going to go ahead and appoint the public defender representing you. Any question about that?
Nothing.
Deputy criminal history?
It's reinstated on Clark on the 16th.
Case number?
2476 MM. Yeah, I forgot. Yeah. Oh, no. Forgot to add it. That shit.
All right, Barnes, on the burglary of a dwelling or conveyance while armed, bond is set at 25,000. The grand theft of a firearm is 25,000. Possession of firearm by convicted or ammo by convicted felon is 15,000. No contact with the alleged victim. Court date's going to be October the 21st at 9 o'clock, and I'm signing a warrant for violation of probation 24-2476. Good luck, sir.
1021. All right, when the green light comes on, sign.
I don't think I've had enough caffeine.
Come on in. Step on the X. State your name.
Chapman Barnes.
Ms. Barnes, before the court on a violation of probation for what was originally battery on medical personnel, possession of heroin, possession of meth, in front of judge register. You understand those charges?
Yes, sir.
Force you represent, Ms. Barnes?
I do, Your Honor. My understanding is from Judge Register, he is holding her without bond. I think it is what it is, Judge.
All right.
Just try to see what we can do about maybe an ankle monitor.
Would judge register? Yes. Good news. The state's October 16th. It's not terrible. It's been worse. I've been given worse this week. So October 16th at 9 o'clock is going to be your court date. You are held without bond by Judge Register. Good luck to you, ma'am.
Yes, sir.
Next. State your name.
Shauna Arrington.
What number is that?
One.
Ah. They got Cruz as the last
It
name.
says Cruz.
Yes, my maiden name was Cruz, but my
I'm
got
no
you.
longer. Yes,
All right, Ms.
sir.
Aaron, you're before the court charged with theft, retail theft. You understand that charge?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. That's true, ma'am?
Yes, sir.
Okay. Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. So you have an attorney now. Any question about that?
No, sir.
Yeah. On history of Ms. Cruz, or I'm sorry, Ms. Harrington. Apologize.
Just a theft out of New Jersey in 17, and that's it.
Pre-trial release, no contact with the alleged victim. Court date's going to be September the 20th at 8:30.
Step to your right to the T. Next. Jones. Red X, ma'am. State your name.
Ma'am, you're before the court charged with domestic violence battery. You understand that charge?
I understand it, yes, sir.
I need you to be given copies of paperwork and advised of your rights. That's true?
Got a copy of the paperwork or you advise of your rights today?
Yes.
All right, ma'am. Based on your application, I find you do qualify. I'm going to go ahead and appoint the public defender to represent you. So you have an attorney now. Any question about that? No, maybe?
No.
She said no.
That's
Just a domestic in 21 and 23.
I was never charged.
You were arrested for it. Show arrest history.
You were charged. You weren't convicted.
Right.
Bond said 2,500, no contact. Court date's going to be September the 20th at 8:30.
Step over to the T. Next. Red X, ma'am. State your name.
Ms. Rivera Morales, you're before the court charged with domestic violence battery. You understand that charge?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. That's true?
Yes.
Based on your application, I find you do qualify. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
Yes, sir.
All right. Deputy, criminal history?
No history, sir.
I understood the Morris County message. She's never been aggressive person and she's a great mother.
Okay. So she and he are going through, they're splitting,
I'm sorry?
they're going through a divorce?
Yeah.
Okay, that's fine. That's fine. That's fine. All right. Mr. Rivera Morales, I'm going to release you on what is called pretrial release. You report to the pretrial release office after court Friday. No contact directly, indirectly, or through a third party, the alleged victim. You understand that?
Yes, sir.
Okay.
We do live in the same house.
Yeah. That's not anymore. You don't. Okay. And if you need to go to the house to get your personal effects, you can get a law enforcement escort to and from the house just to get your personal effects there.
Okay. Thank you.
Yeah. It's gonna be bad for the short term. Okay. I'm just telling you, it's not pretty, and it's just about to get a lot less pretty. To be able to see your kids, but no contact only is to him, not to the kids. All right. Court is gonna be, this is Friday at 8:30. All right. Good luck, ma'am. Last night was a
Next.
beautiful. Yeah.
Red X, ma'am. State your name.
Ms. Smith, you understand the charge?
I'm sorry.
You understand what you're charged with?
Yes.
I understand you give me copies of paperwork and advised of your rights. Based on your application, I find you do. I'm going to go ahead and appoint the public defender to represent you. So you have an attorney now. Any question about that?
No, sir.
Deputy, criminal history?
No history, sir.
Pretrial release, no contact with the alleged victim directly, indirectly, or through a third party. Pretrial release office after court on Friday, September 20th at 8:30 is your court date.
All right. Step to your right to the T. Red X, ma'am. Yes, ma'am. State your name.
Ms. Singleton, you're for the court charge of grand theft. You understand that charge?
Yes.
I understand you've been given copies of paperwork and advised of your rights. That's true, ma'am?
Yes, sir.
Based on your application, I find that you do qualify. I'm I'm going to go ahead and appoint the public defender representative. So you have an attorney now. Any question about that?
No, sir.
Deputy Criminal History, Ms. Singleton?
Outside of Georgia, you had a resisting this year and a theft in 17, and that's it.
Bond set at 5,000. Court date's going to be October the 21st at 9 o'clock. No contact directly, indirectly, or through a third party alleged victim.
Step to your right to the T. When the green light comes on, sign. Next. FedEx, ma'am, state your name.
Candy Crosby or Lisa?
Ms. Crosby, before the court charge of cruelty towards child. You understand that charge?
Sorry, what was that?
You understand what you've been charged with?
Yeah.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
It is.
Based on your application, I find that you do qualify for the services of the public defender's office. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
Criminal history?
I've never been in trouble.
Resisting, that's what you went to court for this morning with you. You had a DW LSR in 22, 1 and 21 with an FTA. Domestic 15. There was a violation of a court order in August and a grand theft in 15.
Misunderstand the question, Ms. Crosby?
What was that?
Bond set at 150,000. Court date's going to be October the 17th at 9 o'clock. No contact directly, indirectly, or through a third party alleged victim or anyone under the age of 18.
Step to your right to the T. Next. Red X, state your name.
And before the court charge of criminal mischief over $1,000 and resisting officer without violence. Do you understand the charges?
Wait, what?
You understand what you're charged with?
Oh, yes, sir.
I think you've been given copies of paperwork and advised of your rights. Is that true?
Yes.
Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. So you have an attorney now. Deputy, criminal history, Ms. Randy?
Outside of Georgia, this year, trafficking heroin, meth with intent, trafficking meth, possession of a firearm during commission of a felony, 23 meth, and a theft.
Been busy. Bond set at 5,000 on criminal mischief, 2,500 on the resisting. Court date is October the 31st at 9 o'clock.
It's your arrest history. Step to your right. Next. Red X, ma'am. Face the TV and state your name.
Ms. Flores, before the court charge of possession of, well, THC vape pen. That's the controlled substance, and also a violation of probation for what was originally possession of paraphernalia, but it wasn't started because I don't put on possession of paraphernalia. That's a wave down from felony court, right?
I was wondering if I could do PTO. Okay.
Yeah. Based on your application, I find that you do qualify for the service of the public defender's office. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir. I was wondering if there would be any probably like possible way I could do PTR until I get to court.
Absolutely, 100% not. So you get a bonus. Let's just back up. You got waived down from circuit court to misdemeanor court, and they gave you probation. That was a gift. And then you pick up a new felony charge while you're on.
Yes, mother-in-law, I tried to return her pen, but.
Bond set at 5,000 on the felony THC. Your court date is October the 31st at 9 o'clock. You're held without bond on the VOP. Your court date is October the 9th at 1:30.
No bond amount?
No.
What is the point even coming up here?
State your name.
Sarah Wells. I'm not in the.
As well as your full court charge of petty with 2 or more prior convictions and central charges.
Yes.
And give compensation. Right, that's true. I am very upset that she's tore up the paper. That really, I mean, I am hurt, deeply moved to tears almost.
Like make everything fucking worse.
Can make it a whole lot worse since I'm the one that's going to see you at the VOP hearing.
Make it that motherfucker got me got that head.
Guess who's back?
Gosh, I'm so scared. Say your name.
As well as based on your application, you do qualify for a public defender. I'm going to go ahead and appoint the public defender representative. Any question about that?
Yes. Thank you.
Yo,
Yes.
you're welcome. Deputy, come on as well.
21 meth para, 20 trafficking in amphetamine, heroin with intent para. Ooh, 19 cocaine, meth, marijuana. Goes back to, looks like 13 locally.
All right. Bond set at 5,000 on the felony petty theft. Court date's going to be October the 21st at 9 o'clock. No contact with Walmart. Fate worse than death. October 21st at 9 o'clock.
Thank you.
Step to your right to the T. Next, next, ma'am, state your name.
I could wander around and see if I recognize it. Ms. Pope, before the court, charged with sale, possession, or manufacture. That can't be right. No.
I did not see it in the complaint.
No, I don't see it in the complaint. THC and cannabis, but that doesn't make it, huh? Full burn marks with vegetable matter consistent with marijuana. That is your paraphernalia. She was going 65 and a 35. I don't know why I need to know that, but it's verified by radar. There's the tinfoil with the residue. Ah, the vape pen. It's the oil, Floyd. It's the oil, the vape pen oil. They're charging the vape pen oil as a felony now.
Yeah, it's THC, but it's not sale, manufacture, deliver.
No, it's the third degree felony. It's the possession of THC oil, which is ridiculous, but here we are because we're waiting on Amendment 3 to go through, I guess. So it's not it's not manufacture, it's not delivery, it's merely the third degree felony of THC oil. I'm writing on the first appearance paperwork. So possession of less than 20 grams of marijuana, I guess for the residue, which is also kind of silly. And then the paraphernalia. Ms. Pope, I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Based on your application, unless you do qualify, I'm going to go ahead and appoint the public defender to represent you. Deputy, criminal history?
Just back in 11, possession of a new legend, less than 20 para and a controlled substance. That's it.
Pre-trial release, random UA, October 7th at 9 o'clock.
Step to your right.
But you want to talk me out of it? I can be talked out of it.
State your name, ma'am.
Ms. Dixon, before the court on violation of probation, what was originally a paraphernalia, you've been ordered held without bond. Your court date is going to be October 9th at 1:30.
Step over.
Other people aren't finding it as hard to stand on the X as that gentleman did earlier.
State your name.
Ms. Ward, before the court charges probation for a driving license suspended revoked felony. You're also before the court on a possession of paraphernalia, possession of controlled substance ×3. You understand those charges?
Yes, sir.
All right. Chief, give copies of paperwork, advised of your rights based on your application. I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
Yes, sir.
All All right, Mr. Ward, on the VOP help out bond, paraphernalia is 1,000. Amphetamines is 5,000. 1,000 and the meth is 5,000. Court date's going to be October the 30th, 9 o'clock. Good luck, Jim.
Step to your right to the T. Garcia bonded or paid the fine. Next. On the X. There you go. Face the TV. No. Step on the X and just face the TV. State your name.
Mr. Tracy.
Mr. Tracy, you're for the court charge of domestic violence battery, false imprisonment, and criminal mischief as a misdemeanor. You understand those charges?
Answer to both of them, not the domestic false imprisonment.
No, do you understand what you're charged with?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. That's true, sir?
Yes, sir.
Based on your application, you make too much money to qualify for a public defender, but the law recognizes your financial situation may change, in which case you could reapply later. You also have the option of hiring your own attorney or represent yourself. Deputy, criminal history?
Shows my history.
Bond said 2,500 on the domestic violence battery, 7,500 on the false imprisonment, and 1,000 on the criminal mischief. No contact, directly, indirectly, through a third-party alleged victim. Court date's going to be October the 21st at 9 o'clock.
Step to your right to the T. Yes, sir. Next. Next. Riddick, sir. State your name.
Jamal Wilkes, good afternoon.
Mr. Wilkes, you're fully court charged with possession less than 20 grams of marijuana and failure to pay fine on a petty theft charge. You understand those charges?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Based on your application, if I find you do qualify, I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
Deputy, criminal history?
He had a petty theft in last year and a visa overstay last year.
All right.
That's it.
Bond said 1,000 on the marijuana, September the 20th at 8:30. And he's sentenced for capious, or 10 days in the Bay County Jail, but may purge out upon payment of $500. That's not $500. That's $300. How much is that? Tell me. What was that? $500. Judge Grammer, I should have known.
All right, step to your right to the T. Next.
He's still with us.
Riddick, sir. State your name.
Ricky David Turner.
Mr. Turner, you're fully court charged with driving under the influence. Do you understand the charge, sir?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes.
All right. Based on your application, you've indicated you're going to hire your own attorney to represent yourself. Is that how you're going to proceed?
Yes, Your Honor.
Excellent. Deputy, criminal history?
Just placed on probation out of Walton County for a DUI and controlled substance in June. You have a DUI in Georgia in 18 and fraud in 24.
All right, Mr. Turner, I find that you're a danger to the community. No bond is going to satisfy my desire to keep the community safe, so I'm going to hold you without bond. Court date's going to be September the 20th at 8:30. Good luck, sir.
Step to your right to the T. Next. Riddick, state your name.
Christopher Boggers.
Mr. Boggers, you're court charged trespass. You understand that charge?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
All right, Mr. Boggers. Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. Bond is $500. Court date's going to be Friday, September 20th at 8:30. Good luck, sir.
Step to your right. Next. State your name, sir.
Palmer, you're for the court charged with petty theft ×2. Do you understand the charges?
You understand what you're charged with?
Yeah.
Mr. Palmer, based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
Yeah.
Deputy, criminal history?
So, misdemeanor probation, and he also has an open NTA.
Got a case number, Mel?
For the probation is 24701 MM.
All right, Mr. Palmer, sign a warrant for violation of probation 24701. Bond set at 2,500 on each of the petty thefts. Court date's going to be Friday, September the 20th at 8:30. Good luck, sir. I got answers.
You think I'll be able to bond that?
What'd he say?
That answer is no. He just held you without bond on the probation. He wanted to know if he could bond out, but he can't.
No.
Sign where the light is. All right, next. Red X, sir. Hello, state your name.
Shanti Keel, good afternoon, Your Honor.
You scared before the court for cruelty or child abuse toward child, domestic violence, battery, and resisting officer without violence. Do you understand the charges?
I'm sorry, can you repeat that?
You understand what you're charged with?
Oh, yes, Your Honor.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
I'm sorry, repeat that, Your Honor.
You've been advised of your rights today?
Yes, sir.
You got a copy of your paperwork?
Yes, sir.
Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
He gave you a public defender.
Okay, great. Thank you.
Deputy, criminal history?
Last year was a disorderly and trespass. Illinois, 21, defacing ID firearms and resisting and domestic in 19. That's it.
Yes, Your Honor, I am his fiance. We've
Uh-huh.
been together for 2 years.
Okay.
And what caused this whole situation to come about, Your Honor, yesterday with the sheriff being at my house, is he had a little bit too much to drink. He decided to contact law enforcement, which I really felt was I did not need law enforcement at my house. He deserved to an extent background with being a chief assistant engineer within the state of Illinois. But I would like to ask Your Honor, as me being his fiance, for him to get treatment for his alcohol. That I would like to request that.
I would like that too, but I can't order him to do that until he gets sentenced to something.
Back to Your Honor.
Yeah, that's.
What I would, say, just if you don't mind, sir, is I would like to proceed on making sure that I drop a no contact order.
Okay, well, y'all have a child in common?
No, we do not.
Is there? Okay. Okay, but your child lives with you?
Yes, sir.
Okay. How old is the child?
8.
Yeah, no. Yeah. Yeah. How can I say this nicely?
Thank you, babe. Sorry, I was talking about fiance.
I can't.
Sorry.
No, you're fine, sir. If you're not going to protect the 8-year-old from this situation, then I'm going to. All right. So on the cruelty toward child, bond set at 50,000. The domestic violence battery, 2,500. The resisting, 2,500. No contact directly, indirectly, or through a third party with either of the alleged victims. Court date's going to be October the 17th at 9 o'clock with no alcohol.
Yes, sir. Thank you, Your Honor.
Step to you, right?
Yes, ma'am. Can I,
He can hear you.
Oh.
Yes. Question.
So Your Honor, well, what's my bail altogether? Or
55.
55? So that's like 500, pretty much.
5,500. Well, depends on which bond you use. Yeah.
Okay. I do have the money. Can I bail myself? Oh, okay.
Yep. Thank you, Your hands.
Thank you for your time. Appreciate
Wait,
that.
wait. Step on the T. State your name,
Take care.
sir.
Mr. before the court charged sale, delivery of methamphetamine, possession of butanidol. I'll never say that. And drug paraphernalia. Do you understand those charges? I see copy of paperwork and advised of your rights. Is that true, sir?
Yes, sir.
All right, sir. Based on your application, you've indicated you're going to hire your own attorney or represent yourself. Is that how you're going to proceed?
Yes, sir.
Good. Deputy, history, Mr. Mangum?
23, controlled substance, resisting false ID, less than 20. 21, dealing in stolen, 18, habitual VOPs. It goes back locally to 2007 with the release out of DOC August the 19th.
Bond set at 50,000 sale, delivery of meth, 5,000 the possession, 1,000 the paraphernalia, random UAs. Court date's going to be October the 21st at 9 o'clock. Good luck, sir.
Step to you. You got a question?
Oh, yeah, what was it again? How much?
56. When the green light comes on, sign for your copy. X.
5,600.
It's 56,000 or 5,600 with the, but that's between you and the bonds. State your name.
Johnny Brown.
Mr. Brown, you're before the court charge cruelty toward a child. Do you understand that charge?
Yeah.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir, I have.
Based on your application, I find that you do qualify for the service of the public defender's office. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
Because you just got out of prison. That's why it's so hot.
Come on, Judge.
Because we're tired of seeing you.
Tired of being too, please.
Good. Then do something about it.
I'm trying. I can't even get no help, Judge.
Stop selling that.
Yeah,
we're
we're
selling, man.
All right. I understand you've been given copies of paperwork, advised of your rights. Based on
Yes,
your
sir.
application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
Sir.
Deputy, criminal history?
19, grand theft auto, 18, DWLSR, loitering, less than 20. Controlled substance, you were charged, not convicted, I don't guess. And then nothing prior between 2009 and 2012 is where that ended, before 18.
Well, what do you want to tell me? Have you read this? Do you want?
I know what I know he did not. We lived together and he has been a single father and I think we're going through the state right now with him and the school. He's
I didn't test my boy, sir.
The kids been.
I did.
Yeah, the kids been, we all know.
I did. I did not test my boy. Not like that.
You read it, right, Donnie?
I've read it, yes, sir.
Okay, I'm just making sure.
Yes, sir, I've read it.
Just read it.
I can't afford to pay anything right now.
You're on the right foot.
What I've heard and what I've seen,
The child clearly stated that he was on a four-wheeler and him and his friend were riding down through the bushes and all heard with my own ears the same way. The child has been in school several times and they gun threats and actual racial threats throughout the school. Then today, when Mr. Collins was on the phone with the bus
I've been having problems with him, sir.
had made the statement that he had made the other. What I know of Mr. Johnny Brown is anything but violent. I mean, I'm not asking you to give him custody. I would
No,
never-
right, yeah.
I would never indicate to any as far as harm. The only thing I'm saying is that if maybe y'all might put him on monitor or something, or give him just an opportunity at a bond or something.
I'll give him bond.
I mean, I'm not.
He's entitled to a bond.
Yes, sir, I understand that. The only thing I'm saying is, from what I know of the man in a short time, is the kid actually needs help. He needs
Okay.
the child himself, and that's all I got.
Okay.
Sounds,
You're fine.
Thank you, sir.
All right, Mr. Brown. Bond said
I can't afford it. I don't even have money for a bond, sir.
we don't have a whole lot to talk about, do we?
Can they free trial me or anything else?
No. Not on this charge. I can't. Well, it's no contact directly, indirectly, or through the third party for him. I don't know where.
I'm his only caretaker.
Okay. Well, he can't have any contact with him while this is pending. Bond's $25,000. The date's October the 7th at 9:00.
How much?
25,000.
Well, that's better than what I normally do on a child abuse. That's about half.
Actually, you gave the lady 150, so about a third.
Yeah, but she was allowing somebody to have sex with her kid allegedly.
Oh, I didn't read them. I don't know.
Yeah, that one was special.
Oh. Okay.
I never even touched my kid though, man.
Go ahead and sign for your copy. Next. Ready, sir? State your name.
Hey, Jackson. Mr. Jackson, for the court on violation of probation for carrying concealed firearm in front of Judge Gay. Judge Gay, in her infinite wisdom, is ordered you held without bond. Your court date's going to be October the 9th at 9:00.
All right, step on the T on your right. When the green light comes on, sign for your copy. Next, Red X, sir. State your name.
Terry Howard.
Mr. Howard, before the court on a fugitive justice warrant out of the state of Georgia. It looks like Floyd County has requested the honor of your presence. The only thing you and I have to talk about is whether or not you're the Kerry Howard that Georgia is looking for. If you agree that you are, it is probably in your best interest to go ahead and sign the waiver of extradition, putting them on the clock to court you.
All right.
All right. Step to the left and sign the 5 copies of the waiver by video in my presence. That puts Georgia on the clock. So
Excuse me, Your Honor.
Yeah.
It don't start when I got arrested.
Yeah, to finish locals first.
Oh yeah, yeah. Look stuff. Start right now.
So the quicker I bond it out, then when it started, I just bonded it out.
When did you bond out yesterday?
Yeah.
That's why you're here today.
October 18th, return date.
So how long they got, man?
You just said October 18th.
Okay.
All right, step over to the T. Now, when the green light come on, you'll sign for your copy of it. Next. State your name, sir.
Gavin Sullivan.
Mr. Sullivan, you're for the court charge. Driving license been revoked and driving a motorcycle without endorsement. You understand those charges?
Sir.
You understand what you're charged with?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true, sir?
Sir.
Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. So you have an attorney now. Any questions about that?
Yes, sir. No, sir.
Jeff, your criminal history?
Nothing since 18. That was carrying a concealed weapon, possession of weapon or ammo by a felon, loitering and prowling, molesting a vending machine, 17 DWSR, goes back to 03.
Just sounds awful. The molesting a vending machine. Like, what did that vending machine ever do to you? Did you whisper to it first? Did you?
I caressed it gently.
You think? Mr. Sullivan, that goes
You
a long
open
way.
that door.
That goes a long way. No, pretrial release because he at least picked up on it. He at least picked up what I was putting down. All right, pretrial release. You can go to pretrial release after court Friday, September the 20th at 8:30. See, sometimes that helps out. Hey, let's do it again tomorrow at 2.
Hey, did they charge it as a felony or a misdemeanor? Is that the right court date?
Misdemeanor.
Okay.
I like it.
All right. When the green light comes on.
Brown versus Brown. It's gonna go to the end of the doc. What do you have? Brown versus Brown. What do you have?
Head case, Mr. Ridings, and you're a special judge. It's
Yeah, we'll be at the end of the docket sooner than usual, so we'll bring it up, okay? Y'all wanna come around? Okay, what do you have?
Judge, we're here on our original motion for contempt. Mr. Brown has not been adhering to the party's time sharing schedule. My client has had, I think, it's been 6 months since they have
Okay, well,
followed the
let's just
schedule.
take some testimony about it, okay? And, these other people come in, they weren't here in a timely manner, they can wait till the end of the docket. How many witnesses do you have?
Well, Judge, I don't know that there's, I don't know that there's a dispute that they haven't been following the time sharing schedule. I'm not sure.
Well,
Testimony wise, what you,
well, the testimony would be that if they want to stipulate the fact that the time sharing has been happening, and then it would.
and I would ask if that's what they're willing to do, and then I think the onus would be on them to show why.
And then the burden of going forward would be placed upon, Mr. Brown as to why it hasn't been happening.
Your Honor, we would stipulate to the extent that the, neither party is receiving the visits as if they're supposed to.
Neither party's done what?
Receiving the visits as the time sharing order says. My client has not saw his son overnight for about the same amount of time that Ms. Coleman's client's not had the daughter overnight.
I just think we need to take some proof on this thing. You know?
Well, Judge, I would point out that they've not filed a motion regarding the son.
I'm saying that on your motion, we need to take proof.
Okay, then I'll call Ms. Brown.
You know, y'all can take a seat there, we'll take proof. Okay, so they have stipulated the fact that that the visitation hasn't taken place as it should have. You want to call your witnesses, Mr. Carter, as to why it hasn't?
Your Honor, in our motion, and I will, Your Honor, in our motion, I'd ask if the court would interview the minor child outside the presence of the witnesses.
I might do that after I hear what the testimony is.
Okay, Your Honor,
I'm not inclined. It's not my practice really to interview minor children. You know, I don't know, and if I do, I always have the presence of my staff attorney.
Yes, Your Honor.
But go ahead and put your evidence on.
Your Honor, I will call Kenny Brown.
Okay. Mr. Brown. You raise your right hand. You swear the testimony about to give us the truth, the whole truth, nothing but the truth.
Yes, sir.
Take a seat, lean forward to the microphone, state your full name.
Kenny Brown.
Mr. Carter.
Mr. Brown, would you agree that the visits between Miss?
Probably go better if you came up with the podium. The acoustics aren't good today. Thank you.
Mr. Brown, do you agree that the visits between Miss Lindsay Shootman Brown and your daughter are not going completely as scheduled?
Yes, sir.
What is your understanding as to what the schedule is supposed to be?
My understanding, I think, the last motions was a 50-50 order for both my daughter and son both.
All right. And what is the current visitation arrangement between you and Miss Brown?
There is no arrangement. Kaylee lives with me and Colton lives with her. That's pretty much it.
All right. Who made the decision for it to go that way?
My daughter, Kaylee, and then Colton, my son.
Was there like a dispute or something that led to this, or how did it come about?
Yes. My son got in trouble by me. When he got in trouble, he went to his mom's house and he's pretty much not come back.
Judge, I'm going to object to relevance. The son is not part of this motion.
Might be part of the motion, but it might be part of the problem. My goal here today is to do a global situation here. And if I decide that you need more time as far as the motion on the son is concerned, I won't make any decision.
There is no motion on the son.
I understand.
Okay.
I understand what you say to me. There is no motion, but I'm wanting to do this as background information to see if I can see what the entire picture is here. And hopefully, even if there isn't a motion, we can do a global situation to proceed. But let's go to the daughter. Okay, I understand the son. From the previous hearing, I know a little bit about the conflict with the son, getting in trouble and that sort of thing. Go ahead.
Do you understand what the conflict is between your daughter and her mother?
Yes, what she's told me.
Okay.
How old is the daughter?
Almost 17.
And since we've been here, has the daughter visited with her mother?
Yes, frequently.
Is the daughter here today?
Yes, Your Honor.
She could be excluded from the court right now because she's gonna be a witness. Okay, go ahead.
Can you explain what you mean by frequently? How often does she see her mother?
She goes down there often. She was there last night to eat. She checks in, I don't know, 2-3 times a week. She goes over there. She was just over there this last Sunday. She goes and eats and kind of hangs out.
Has she had any overnight visitation with her mother?
Yes,
How many of those are you aware of?
I'm not for sure.
Okay. From your perspective of it, is the relationship between your daughter and her mother improving, especially since we've been coming to court?
I thought it was.
Are you discouraging your daughter from seeing the mother?
Absolutely not.
Are you interfering in her visits with the mother?
Absolutely not.
Have you encouraged her to see her mother?
Yes, I have.
Last time we were here, that I was here on this case, there was some therapy scheduled with the daughter and the mother. How did that go?
She went to either 3 or 4 of the therapy sessions.
Who's she?
My daughter, yes, Kaylee.
All right, and how did those end and why did they end to your knowledge?
She went to 3 or 4 of them. She got sick. I called down to the doctor's office to reschedule an appointment. They advised me that she didn't even have an appointment that day and that her mother would have to reschedule an appointment because I guess her mother is the one that wanted the therapy, and we were never contacted again for any kind of rescheduling.
Outside of that, there was some orders of her seeing the mom in a couple of restaurants and things. Did those visits take place?
Yes, they did.
And are those what led to the somewhat of reconciliation between the two of
I
them?
believe so. Yes, sir.
And just for the record, have you done anything to interfere with these visits?
Absolutely not.
Have you tried your best to follow the court order?
I have. She drives a vehicle. She's back and forth to Salina every single day. Her mother lives on the way to Salina. She's free to stop at her mother's anytime she wants.
Your Honor, I don't have any particular questions other than that.
Where is the child enrolled in school?
Clay County.
Okay, you may inquire.
So, Mr. Brown, you don't dispute that the current order is every other week with Kaylee, between you and her mother?
Do what?
The schedule is supposed to be under the current court order every other week.
I couldn't tell you what the actual order is. We've been in court so much with you filing motions, so I honestly don't know what the current order is at the moment.
What do you got?
Did you?
Did you have a copy of the most recent?
Well, I think he testified that it was 50-50 to Mr. Carter. You did testify to that.
It was at one time, but you, like I said, you all have filed so
I
many
understand
motions.
that. Do you have a copy of the most recent?
I mean, regarding time sharing.
Yes.
And Judge, I actually don't know if I have a copy of the order. This was something we went in front of the Domestic Relations Commissioner about. So I don't know that it ever got reduced to anything that came to the court file and came to this court. But do you recall
What court?
on February 7th?
What court?
Do you recall us having a hearing in front of Mr. Sohn
Yes, ma'am.
on February 7th?
Yes, ma'am.
And do you recall at that time we agreed to week on, week off?
Yes, ma'am.
Okay. And have you been in any other court hearings since then that have changed that?
We've been in a couple, and the last one was in Clinton County. I don't know if it was changed. At that time, she was still living with me. And it was agreed that she went to the therapy sessions and then she met her mom at the restaurant, and it was never discussed to go back to the 50-50.
Okay, we were in Clinton County, I believe June 7th. Does that sound right?
Yes, ma'am.
Okay, and that was because we had filed a motion to compel you to follow the 50-50. Is that your recollection?
Yeah, you're reading it, yes.
Okay, and we made an agreement to attempt to get back to the 50-50 and agreed to.
Was that reduced in order?
I don't think so, Judge. It was in front of you. We put it on the record. In front of you. And you agreed that she would do the meals with the mom and the therapy sessions.
Yes, ma'am, and she did.
and then we would revisit. You said she only missed one therapy session?
The final therapy session, yes. I guess I used to say the final one. That was the day that she was sick and didn't go, and it was never rescheduled.
Okay, so if the therapist stated she missed two, that you're saying that would be incorrect?
I don't know that she missed any. She went every time she was supposed to.
Okay, and
Office where it was at,
who was that?
Dr. Lowy's office. I didn't call to reschedule. I called her to her. She wasn't going to be there. It wasn't my job to.
And so then you just stopped pursuing it at that point?
Repeat that, please.
You just allowed Kaylee then to stop going to therapy at that point?
I guess, yes.
Okay, and at that time, as far as you know, the 50-50 order is still in place?
I'll be honest with you. I couldn't tell you because I told you the motion that you all filed and it was never discussed and we've never been back to court. I've already explained myself.
Are you aware of any order that changes the 50-50?
I don't know what the order was in June or July when we agreed to go back to when she went to the therapy sessions and to a rebuilding situation to go eat with her. It was never discussed that we went back to a 50-50 after she got done with her things.
I've got a problem. The problem I have is that these agreements in front of Solomon and me weren't ever reduced.
Okay.
That's a problem. So you're asking him what he knew. What he knows or what was said and what was in the order are two different things. You know, there was an order. So I would suggest that what we do is proceed with this thing to see if we'll make one more attempt. Now, I'm willing to interview the young lady. She's 17 years old, you know, and I'm willing to interview her with my staff lawyer being present. But I want to know if she is willing to visit her mother or abide by a court order. I don't want to do anything to the child, but, you know, she's got to abide by court order. It would appear to me that it's pretty hard for a father or a mother to force a 17-year-old to do very much of anything they don't want to do.
I agree, Judge. I think the concern and problem I have is Mr. Brown is certainly well-versed in the court process. And he never filed anything to suspend mom's visits. He never filed anything to stop her visits. He never filed anything indicating there was a risk to Kaylee to being at mom's. He's even testified that she's gone over there voluntarily the last 3 Wednesdays.
Well, I'm going to try to resolve that here today.
Okay.
I mean, what we have to do is look forward.
I agree.
And try to get some resolution that will help reestablish. Now, evidently, the oral agreements between the parties didn't fell on deaf ears when it comes to the child, because the child wasn't willing to abide by those, evidently, if that's what she tells me.
And Judge, I can tell you that there was, it looks like May 22nd of 23, there was a recommended order by the DRC that was that was visitation on a week-to-week basis, beginning on Fridays at 6 p.m.
Was it ever reduced? Did I ever sign anything? See, we're running into things of why I don't have a domestic relations commissioner anymore. Okay, I don't have a domestic, these agreements and things are gone.
Sure.
And they work out until they don't.
Right.
You know what I mean?
You know.
So what I want to do is the two lawyers get with the parties and go back and see what we can do from this forward on. And then I will instruct this young lady and give her an opportunity to tell me in chambers. But the problem with in chambers thing, the attorneys have a right to be there. So I don't really know what we accomplished by being in chambers. I mean, we've already said enough that it won't change anything as to what the public knows about it. So I just think we let them talk about it with each other, or I can call her out here now and let her testify. Either way.
I mean, Judge, I think that it's going to have to be the child, because I think that it
You
feels
agree
as
with that,
though the
Mr. Carter,
stance
to have
of
the child come out and testify?
Your Honor, I would just ask that the courtroom be cleared if,
I'm not going to clear the courtroom. She's 17 years old. It won't do anything. I will make sure it's not broadcast anyway. I don't think they're family members and
Ms. Thurber, could I have you unmute and tell me why you're in the Zoom hearing, ma'am? You're muted, ma'am. I can't. There you are. Can you tell me why you're here?
Yeah, my name's Jessica Davis, and I'm here because I couldn't make it to court, so I asked if I could get a Zoom hearing.
All right, we need to rename you because you don't have that name on your Zoom account. All right.
Right, I'm using my mom's because my other phone doesn't work ever.
Again,
And the last time that I
that's why
went
I'm
on the
asking. That's why I'm asking. So we'll unmute you. We'll talk to you here momentarily. So for the folks that are present with us here in the courtroom, when I call your name, I'm going to ask you to come up to the podium in front of me. I'm going to ask you your name and your date of birth. I'm going to explain the reason that you are before the court today. I'm also going to discuss your options today. One of the things I cannot do is provide you legal advice. So if you have strategic questions or those sorts of things, I'll have you just take a seat. You certainly can consider your options. I'm not trying to rush anyone through the process. We do also have folks that you're going to see on the table, on the television above you or over to my right that are joining us here from the Clark County Jail. I have a more limited time with the folks who are in custody. So those matters oftentimes do have to get called near the front of the docket. I have one other person who is on Zoom that we don't have a name for. It's EDM. If I could have you unmute and tell me what matter you're here on, please.
I'm here watching for Caitlin Moorhead.
Okay, well, we're streaming on YouTube, sir. We can't have people just hanging out on Zoom. So if you want to go on YouTube, you can search Battleground Municipal Court and watch it that way, okay?
Okay, I'm only on the, okay.
Ms. Gaffney, are we ready on the Carla Fuller matters?
Yes, Your Honor. Thank you.
Ms. Fuller, can you hear the court, ma'am? Carla Fuller, can you hear the court?
Yes, I can.
Thank you, ma'am. Can I have you state your name and date of birth, please, for the record?
Carla Fuller, 3/23/62.
Okay, so Ms. Fuller, looks to me like you are making a first appearance arraignment on a protection order violation. A protection order violation, ma'am, is a gross misdemeanor that is subject to 364 days in jail and a $5,000 fine. I did previously review the police report back on the 21st of August. I found probable cause at that time. It looks like subsequent to that, we had to issue a warrant because you didn't show up for arraignment. You also are appearing on a second cause number where you were on a stay of proceedings. The stay, it looks like, was entered in April. Looks like that there was some statements about felony drug court entry and those sort of things. Ms. Gaffney, your attorney, is with us here in the courtroom. Ms. Gaffney, how is Ms. Fuller asking to proceed today?
We're entering a not guilty, Your Honor. We'd like to track the cases. She goes to court on her felony. I don't have all the details on that on the 25th of this month, and she said the bail is $20,000 and she's not going to post. I'd ask Your Honor to consider release on these.
Ms. Carmi?
Your Honor, we don't anticipate she'll be posting on the felonies. We are fine releasing on ours. When we set, we would like that set for a revocation hearing as well. We'll get that filed this week for the stay.
Yeah, both cause numbers, it looks like, are on the return to court. So we'll track both cases together. Ms. Gaffney, you said the date was the 20th was the next felony?
25th, the 25th on the felony,
okay.
Next Wednesday.
Okay, so let's set that then accordingly to when we have Ms. Gaffney, perhaps. Ms. Gaffney, are you with us? Madam Clerk, just help me out on a future Ms. Gaffney date within the next couple weeks.
I'm here the 26th of this month, the 10th of October.
Ms. Gaffney, what's your preference between the 26th and the 10th in terms of return date for Ms. Fuller?
26 would be fine. Thank you, Your Honor.
Okay. So Ms. Fuller, we're going to see you next week. It sounds like it's going to be after the court appearance that you have in Clark County. That's going to be on September 26th. If you are out of custody, ma'am, that's going to be at 10 a.m. If you are
Okay.
still in custody on the felony matter, you're going to be brought over from the jail at 8:30. The Battleground holds, if there are any, I'm assuming there is on 490. Those holds are released at this time. So Ms. Fuller, on your misdemeanor cases, I am going to release you on your recognizance at this time. Certainly, if there is a protection order in place, ma'am, you need to continue to abide by that order, or there's going to be continued charges. Do you understand?
Yes, I do. Thank you.
Okay. We're going to get you some paper over at the jail. Once you have your documents, you are free to go.
Okay, thank you.
I have Nicholas Albers in the courtroom. Come on up here. Sir, if I can have you just state your name and date of birth, please, for the record.
Nicholas Albers, date of birth is 8/7/88.
Mr. Albers, you're making a first appearance arraignment on a charge of driving while suspended in the 3rd degree. That charge is what's called a simple misdemeanor. It's subject to 90 days in jail and a $1,000 fine. I did review the associated police reports with your case. I did find what is called probable cause. Because this is a criminal charge, sir, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened for a court-appointed attorney?
Yes.
Okay, I'm gonna ask you some,
What's the process of screening, if I
I'm
can?
gonna ask you some questions. Do you receive any manner of state assistance at all?
Yes, food stamps.
Okay, I'm gonna find you do qualify for a court-appointed attorney. Court will assign Brandon Campbell. So what we're gonna do, Mr. Albers, is enter a not guilty plea at this time. That's gonna preserve all of your rights and keep all of your options open. I'm gonna assign 2 future court dates. The first is what's called an attorney pretrial date. That's gonna be on October 3rd, 2024. That's a date that Mr. Campbell will appear. It's not a required court date for you. Your next mandatory court date is going to be on the 17th of October, 2024 at 10 a.m. You can be in person or on Zoom, but you need to be present in some way that day. Your release conditions, sir, are to violate no laws, appear at all mandatory court dates, notify the court of any change of address or phone number. You're not to drive without a valid license and insurance, and I am releasing you on your recognizance. So Mr. Campbell can be in touch with you. Is there a phone number I can write on the form here?
Yeah, it's 503-969-3837.
The same place you checked in for court this morning, where the glass partition is, on a table on the left-hand side is a table with business cards on it. Get one of Mr. Campbell's cards, give his office a call today, let him know you've been assigned as his client, okay?
Okay.
Paperwork will be at the desk by the door. Thank you.
Thank you.
Caitlin Moorhead. Good morning, ma'am. Can I have you state your name and date of birth, please, for the record?
Caitlin Moorhead, 110801.
Ms. Moorhead, you're making a first appearance arraignment on a charge of physical control. Physical control in the state of Washington is what is called a gross misdemeanor, and it's subject to 364 days of jail and a $5,000 fine. It's also a charge that if you're convicted of it can carry mandatory jail time, license suspension. It's called an ignition interlock device and a requirement for high-risk insurance. I have reviewed the associated police reports with your case, and I have found what is called probable cause. Because this is a criminal charge, ma'am, you have several important rights, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened for a court-appointed attorney? Are you planning on hiring an attorney yourself? Do you want to talk to the prosecutor? I would not recommend entering a plea. You have no idea what's going to happen if you do. So, all right. So we're going to enter a not guilty plea at that time. This time that'll preserve your rights and keep your options open. I'm going to set 2 dates moving forward. I'm going to set what's called a pro se pretrial date. That's a date that you can interact and talk to Ms. Carmi. That's going to be at 2 o'clock in the afternoon on the 3rd of October, 2024. If the case is not resolved that day, we're going to set another tracking hearing on the 31st of October, 2024 and is also going to be at 2 p.m. Those are both mandatory court dates. Your release condition, ma'am, is to violate no laws, appear at all mandatory court dates, notify the court of any change of address or phone number. You're not to consume or possess any alcohol, non-prescribed drugs, or controlled substances while your case is pending. You're not to drive without a valid license and insurance. I am releasing you on your recognizance. So the city attorney can be in touch with you. Is there a phone number I can write on the form?
360-821-7310.
Okay. Ms. Carmi's office is likely also going to give you a business card so you can be in touch with them. There's nothing that we've done today that prevents you from choosing to hire an attorney later on, okay? Paperwork will be at the desk by the door. Thank you, ma'am.
Thank you.
All right, Ms. Davis, if you want to unmute, please. Ms. Davis, I'm gonna have to come back to you. You're still muted.
Okay, there. Does that work?
Yeah. Can I have you state your name and date of birth for the record?
Jessica Davis, 12/11/82.
Ms. Davis, you are making a first appearance arraignment on a driving while suspended in the first degree. Driving while suspended in the first degree, ma'am, is a gross misdemeanor, subject to 364 days in jail and a $5,000 fine. It's also a charge that carries mandatory minimum jail time that is calculated based on the number of previous driving while suspended in the first degrees you've been convicted of. The first time it requires 10 days of jail, the second time 90 days of jail, the third time 180 days of jail. Every time after that, it will always be 180 days in jail. I have reviewed the associated police reports with your case, and I have found what is called probable cause. Because this is a criminal charge, ma'am, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened today, ma'am, for a court-appointed attorney?
Yes.
I'm going to ask you some questions about your income to see if you qualify. Do you receive any manner of state assistance at all?
Food stamps.
I'm going to find you do qualify for a court-appointed attorney. Court will assign. Court will assign Brandon Campbell. We're going to enter not guilty pleas today for you, Ms. Davis. That's going to preserve all of your rights and keep all of your options open. I'm going to assign 2 future court dates. The first is going to be the 3rd of October, 2024. That's a date that Mr. Campbell will appear. It's not a required court date for you. Your next mandatory court date, ma'am, is going to be on the 17th of October, 2024. That's going to be at 10 a.m. You can be in person or on Zoom, but you do need to be present here in some way, shape, or form.
Okay.
The release conditions are to violate no laws, notify the court of any change of address or phone number. You are not to drive a vehicle without a valid license and insurance. If I get any indication that you are continuing to drive, it looks like right now you have 3 driving while suspended first degrees pending. I will revoke your release and I will put you in the Clark County Jail. Do you understand?
Yes.
I'm also placing you on administrative pretrial release with Clark County pretrial release. That does not require that you appear in person, but it appears that you do call in telephonically. That is based on the previous warrants that you've had on your cases over time. So Mr. Campbell can be in touch with you, ma'am. Is there a phone number I can write on the form?
360-356-6613.
We're going to be mailing you some court paperwork, along with information on how to contact your attorney. Are you still getting your mail on North 2nd Avenue in Kelso?
Yeah, do you want an email address?
I think we have an email address for you, ma'am. Let me look.
Yeah, it should be fawndavis1982@gmail.
We do have that email address as well, ma'am. Okay, we're going to send you some paperwork. If there's nothing further, you can log out, ma'am.
Okay, thank you.
Thank you. Ms. Gaffney?
Your Honor, we have Christopher Smith reappearing this morning on arraignment. And we have audio at the podium this week.
Yep.
There we go.
All right, Mr. Smith, you are making a, well, it looks like you're being rearraigned on a charge of driving while suspended in the 3rd degree, which is a simple misdemeanor subject to 90 days in jail and a $1,000 fine, and operating a vehicle without an interlock device, a gross misdemeanor subject to 364 days in jail and a $5,000 fine. These are charges that originally took place in April. Probable cause was found shortly thereafter, it looks like. Also in April, looks like then what happened was that you failed to appear in court and a warrant was issued in May. And looks like law enforcement caught up with you and took you into custody. Ms. Gaffney, what else do you want to tell me?
Just that he kind of panicked because he couldn't afford to get the ignition interlock. I've read him the riot act. Your Honor was very clear with him last time about what he needed to do, and he hasn't been able to do that. He wasn't able to cancel the cowlets. We made an agreement that he's going to stay in touch with me on a weekly basis. I stay in good contact with my clients. We're going to try to see what we can do with DOL. I understand I'm asking a lot. He's here with his close friend. She had a family tragedy. Her husband was killed by a motorcycle accident. She's extremely distraught, worried you're going to take him into custody. I have all the same address information that he had. So email, phone, you can fill all that out. I know we're asking for a lot. We'd ask Your Honor to consider recog.
All right, Mr. Smith, I trust Ms. Gaffney more than you, so I'm going to rely on her to have you get to court. If you fail to appear, I mean, on the positive side, you have no new charges to my knowledge.
Correct.
So that's better than some folks that are appearing today. But again, if you fail to appear again, you're going to be on the monitor from the jail the next time I talk to you, okay?
Yes, sir.
Right. Assigning 2 future court dates. The first is an attorney pretrial. That's going to be on the 3rd of October. The second is your next mandatory court date, Mr. Smith. Easy day to remember. It's on the 31st of October. It's going to be at 10 a.m. You can be in person or on Zoom, but you need to be here. Release conditions to violate no laws appear at all mandatory court dates. Notify the court of any change of address or phone number. You're not to drive without a valid license and insurance. I'm going to release you on your recognizance. Don't make me regret that. We're going to get you some documents, Mr. Smith, at the desk by the door. Once you have it, stay in touch with your attorney. Do what you're supposed to do.
Yes, sir.
Thank you, Your Honor.
All right, I'm going to take a quick survey of who is here. If you hear your name, hello, ma'am. Can I have you state your name and date of birth, please, for the record?
Autumn Bishop, June 6, 2000.
Ms. Bishop, making a first appearance arraignment on a charge of driving while suspended 3rd degree. That's a simple misdemeanor subject to 90 days in jail and a $1,000 fine. I did review the police reports. I did find probable cause. Because this is a criminal charge, ma'am, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, the right to an attorney. Would you like to be screened for a court-appointed attorney?
No.
Okay. Do you want to represent yourself and talk to the prosecutor?
I guess.
Okay. So we're going to enter a not guilty plea, and I'm going to schedule a time for an opportunity for you to talk to the prosecutor. We're going to set 2 future court dates. The first is going to be a pretrial conference on the 3rd of October, 2024 at 2 p.m. You can be in person or on Zoom, but you need to be here in some way, shape, or form that day. If the matter does not resolve that day, we're going to schedule a readiness hearing for the 31st of October, 2024, also at 2 p.m. Your release conditions, ma'am, are to violate no laws, appear at all mandatory court dates, notify the court of any change of address or phone number. You're not to drive without a valid license and insurance. I am releasing you on your recognizance. So the city attorney can be in touch with you. Is there a phone number I can write on the form here, please?
360-442-0402. Yes.
Okay. We're going to get you some documents, ma'am, at the desk by the door. The city attorney's office is also going to get you some contact information. Once you have that, you're free to go.
Okay.
Thank you. Eva Renteria.
Mr. Camp.
Hello, ma'am. Can I have you state your name and date of birth, please, for the record?
Eva Renteria.
$119,1985.
We might retirement gift for it.
Ms. Renteria, you are making a first appearance arraignment on a charge of driving while suspended in the third degree. That's a simple misdemeanor, subject to 90 days in jail and a $1,000 fine. I did review the associated police reports with the case. I did find what is called probable cause. Because this is a criminal charge, ma'am, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened for a court-appointed attorney?
Sure.
Okay.
Yeah.
I'm going to ask you some questions about your income to see if you qualify. Do you receive any manner of state assistance at all?
Food stamps.
Okay, I'm going to find you do qualify for a court-appointed attorney. Court will assign. Brandon Campbell. So Ms. Renteria, what we're going to do today is enter a not guilty plea that's going to preserve all of your rights and keep all of your options open. I'm going to assign 2 future court dates. The first is a date that your attorney will appear on. That's going to be the 3rd of October, 2024. Not a required court date for you. Your next mandatory court date is going to be on October 17th, 2024 at 10 o'clock in the morning. You can be in person or on Zoom, but you need to be here that day. Your release conditions are to violate no laws, appear at all mandatory court dates, to notify the court of any change of address or phone number. You're not to drive without a valid license and insurance. So Mr. Campbell can be in touch with you. Is there a phone number I can write on the form here?
971-323-2628.
Okay. We're going to get you some documents, ma'am, at the desk by the door. Once you have your paperwork, the same place you checked in for court where the glass partition is, go over there, get a business card from Mr. Campbell, call his office today, let him know you've been assigned as his client. Thank you. Right at the table. Vanessa Husafluke. Hello, ma'am. Can I have you state your name and date of birth, please, for the record?
Vanessa Hossaflick, 03-17-1997.
Ms. Hossaflick, you're making a first appearance arraignment on a DUI. DUI is a gross misdemeanor. It's subject to 364 days in jail and a $5,000 fine. It's also a charge that carries mandatory minimum jail time, license suspension, requirement for ignition interlock, and a high-risk form of insurance called SR22.
That's good.
I did review the associated police reports with your case. I did find what is called probable cause. Because this is a criminal charge, ma'am, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened for a court-appointed attorney? I'm going to ask you some questions to see if you qualify. Do you receive any manner of state assistance at all?
Yes, EBT.
Okay, I'm going to find you do qualify for court-appointed attorney. Court will assign. Mr. Campbell? All right. All right, we'll assign Mr. Campbell. Going to assign 2 future court dates. The first is going to be on the 3rd of October. It's a date that Mr. Campbell will appear. It's not a required court date for you. Your next mandatory court date, ma'am, is going to be on the 17th of October, 2024. That's going to be at 10 o'clock in the morning. You need to be in person or on Zoom, but you need to be here that day. I'm going to set the following conditions of release. You are to violate no laws. You're to appear at all mandatory court dates. You're to notify the court of any change of address or phone number. You're not to consume or possess any alcohol, non-prescribed drugs, or controlled substances while your case is pending. If I get any indication that you're drinking during this case, I'm going to revoke your release. So don't drink. Okay. You're not to drive without a valid license and insurance. I am releasing you at this time on your recognizance. So Mr. Campbell can be in touch with you. Is there a number I can write on the form here?
Yes, it's 971-901-5430.
We're going to get you some paperwork at the desk by the door. After that, go to the area where the glass partition is, get a business card from Mr. Campbell, call his office today, let him know you've been assigned as his client, okay? Thank you, ma'am.
You're all right, any custody matters, right?
Yep. Which one is that?
Brett Judd, I'm bringing the paperwork to you.
Thank you. Mr. Judd, can you hear the court, sir?
Yes, sir.
Can I have you state your name and date of birth, please, for the record?
Brett Lee Judd, April 30th, 1999.
Okay, go ahead, Mr. Campbell.
And Your Honor, unfortunately, I was really hopeful that Mr. Judd could resolve today. He and I went through the discussion of working towards getting towards a guilty plea statement, just in all honesty. And I just have a significant concern that he's not capable of understanding what's happening today, or certainly not able to assist me in his defense because of a catastrophic mental illness. And so at this point, I have to ask for a 1077. It's been filled out for an in custody evaluation, which I think is what Your Honor is going to order. I do want to let you know that Mr. Judd has been speaking with some folks relating to the past experiences he's had with Western State Hospital. He's a True Blood class member, and so he does have some funding for housing. He's been speaking with an organization that I'm not super familiar with called the Wellness Organization, that he believes he has some supportive housing in place for when he is released, which is great. And my hope is, if Your Honor orders an in-jail evaluation, that with that work, we can then do an out of custody restoration program. That's of course something we'll have to speak about in the event he's found incompetent by DSHS. But I just wanted to be fair to Brett and ask Your Honor to give him a chance at an out of custody evaluation, even though I understand that there's currently bail in the matter and that I don't really have a change in circumstances other than something that may not be helpful for his future appearance, and that I'm saying that I don't believe he's currently competent.
We're going to maintain Mr. Judd's current bail and release conditions that have been previously set. Do we want to set this out 2 weeks? Or 3
I don't
weeks?
have my calendar on me. What is the next date that I'm here? Should be 2 weeks out. If we could, I think that they can probably do an in custody evaluation, get us a report by that date. And if not, certainly we can kick the can on it. Your Honor, I apologize if that happens, but just as a courtesy to Mr. Judd. I mean, the result today was hopefully that he was going to be released, but I understand.
So, Mr. Judd, we're going to be seeing you back here on October 3rd at 10 o'clock. There's going to be some evaluators coming from Western State to talk to you. And then hopefully we're going to get a report back to see if we can keep going on the case, okay?
Okay, yes, sir. How long until October 3rd? It's about 2 weeks, Brett. Keep your head up in there and talk to the doctor when he comes to see you or she comes to see you, please. Okay.
All right, thank you.
Thank you, Joe.
Ms. Ward, you ready on Ms. Walling?
I am, Your Honor.
Ms. Walling, can you hear the court, ma'am?
Yes.
Can you state your name and date of birth, please, for the record?
Melissa Walling, 13190.
Go ahead, Ms. Ward.
Your Honor, we had previously entered she's making first appearance on a failure to appear. We'd previously entered a not guilty plea to this charge. We're asking to maintain that not guilty plea and set this matter in the normal course for a pretrial as well as a readiness hearing date. We are asking for release on our own recognizance. I will address that when Your Honor is ready for me to do that.
I'm assuming that there is bail on the March 28th, 2020.
There is, Your Honor. There's bail in the amount of $30,000. She's unlikely to make that bail, but she does have a new residence that I have put on the form. She does have family and friends in the area. She is working currently and has an additional job prospect. So if for some reason she is able to make that bail, we are asking that she be released on a recognizance on this with those 2 court dates out in the future, and submitting that she does have sufficient connections with the local area to assure her reappearance.
And to make sure, Ms. Ward, that I heard you correctly, was that 3 or 30,000?
30, Your Honor.
30. Okay. Ms. Carmi?
That is correct. I mean, I think the city probably believes she's not able to post that. I think just the overarching concern is how old this case is. There's been numerous warrants on this case. I don't know that I see the benefit of additional bail in our case, but I don't think release on recognizance is appropriate. I do think there needs to be some check-in conditions, or I think we're just going to be in a cycle she does post $3,000 from a friend or family member, I have reason to believe we won't see her back here.
I think the thing that we're running into is in all candor. So Ms. Ward has set this out to the 31st, which is, I think, an appropriate date. That said, that's going to be about 40 plus days elapsed on a 60-day calendar if I set a nominal bail. Whereas if we do release Ms. Walling, there's going to be a little bit more discretion in regards to our timeframes.
I agree.
And I agree with the sentiment that bail was really the only thing that seemed to get Ms. Walling to come to court in a 2-year-old case. That said, I am going to release the Battleground hold today. Ms. Walling, you're not going to be held on this case, ma'am. We're going to have you back on October 31st. If you are still in custody at that time, you'll be appearing from the Clark County Jail. If you're out of custody, you need to be in the court here in Battleground. Again, October 31st at 10 a.m. Do you understand, ma'am?
Yes, sir, I do.
You're also not to go to any Walmart stores while your case is pending. And if you do post bail, you are on administrative release on this case if you do get out, okay?
Okay, Miss Wheeler has, or not Miss Wheeler, Miss Ward has an explanation as to why I missed court too, and I would like to apologize. If she were to give you the reason, it might explain things a little bit more.
And again, I've released you on this case. You're gonna have to attend to your matters that took place in March 1st. So we'll see you back hopefully again on the 31st of October.
Definitely. Thank you so much.
Ma'am.
And I apologize.
Thank you, Your Honor.
You. Eric Chischenko. Hello, sir. Can you state your name and date of birth, please, for the record?
Eric Tishenko, 4/14/2002.
Mr. Chischenko, you're making a first appearance arraignment on 2 charges. The first is failure to transfer title within 45 days. That's a simple misdemeanor subject to 90 days in jail and a $1,000 fine. The second is a trip permit violation. That is a gross misdemeanor subject to 364 days in jail and a $5,000 fine. I did review the police reports. I did find probable cause. These are criminal charges. Because of that, you have several important rights, including the right to remain silent, the right to a speedy and public trial, the right to an attorney. Would you like to be screened for a court-appointed attorney?
No.
Would you like to represent yourself and enter a plea of not guilty at this time?
Yes.
Okay, not guilty plea is received. I'm going to set 2 future court dates for you, sir. The first is going to be on the 3rd of October. That is going to be a mandatory court date that day at 2 o'clock in the afternoon. You can appear in person or on Zoom, but it gives you an opportunity to discuss your case with the city attorney. If the matter is not resolved that day, we're going to see you back on the 31st of October, 2024. Again, also at 2 o'clock in the afternoon, again in person or on Zoom. Those are both mandatory court dates. Your release conditions include violating no laws, appear at all mandatory court dates, notify the court of any change of address or phone number. You're not to drive without a valid license and insurance. I am releasing you on your recognizance. So the city attorney can be in touch with you. Is there a phone number I can write on the form here?
Yes, 360-726-1738.
We're going to get you some documents, sir, at the desk by the door. The city attorney's office is also going to get you some contact information for them. Once you have that, you're free to go. Thank you.
Thank you.
So Ms. Gaffney, can I borrow you for just a sec?
Yes, Your Honor.
So Kayla Scare is a client of yours currently who has a new charge she's being arraigned on today. I'm going to give you the existing file and the new file. I would like you to speak to her before she comes up in front of me, okay?
Actually, I've reviewed the probable cause and I talked with Kate.
You're good? Okay.
And her mother. I'm aware of the new charge.
Okay, let's call her up then. Come on up, ma'am.
And my understanding, Your Honor, is there was an issue with the probable cause in district court, and that's what I'm told by the committee.
there was an issue with, maybe they didn't
They
have
were
it.
finding probable cause. I
That's-
reviewed the probable cause a few weeks ago when the incident occurred.
This is new incident and I was not there at district court. I did receive the notation back from district court judge that they did not find PC. It was a CCSO filing, so sometimes what happens is they just don't get the PC statement. I don't know. The city would make an offer of proof that we believe PC is outlined properly in the statement, indicates a visible injury on the alleged victim. And so
I made a finding on PC as well. Okay, so Ms. Gaffney, how is Ms. Scare? So she's got 2 pending assault 4s now. How is she asking to proceed on the new charge?
We're going to enter not guilty, Your Honor. We waive the reading of the information. Her address information is all the same. She does have a lot of medical issues and disabilities, and so it's difficult for her to communicate with the police because she seems like everything is fine when actually mentally she's not. But people don't understand that, so it's very hard. I understand how serious the nature of the offenses are, and so does she.
Yeah, this is a difficult case, I think, for everyone involved, Your Honor. We have spoken to the alleged victim from the previous charge and became aware that there's certain medical and caregiving needs. This does appear to be more of a mental health case. When you have repeat assault 4s, I think the preference is probably an NCO. Mr. Treat, the alleged victim, is adamant against that because of caregiving needs. So, and I think probably it would render the defendant houseless at that point, which probably will further exacerbate mental health. So, my hope, and the city typically relies pretty heavily on NCOs in this case. I'm kind of going out on a limb here and departing from my normal procedure and hoping that Ms. Gaffney and I can craft a mental health remedy to this in lieu of an NCO. Maybe a shorter return, hopefully, so we don't end up with new charges, and get her enrolled in something. That's the city's request. Obviously, I can't guarantee there's not going to be a further charge. That's kind of where I'm at this point with these individuals.
One of the things I have difficulty with, ma'am, is that the release conditions here to start with for you were extremely lenient. I'd say probably 70% of the people who come in front of me on a first offense case on assault for domestic violence are probably going to have a no contact order put in place. I think that the city showed you a remarkable amount of grace in not requesting that the first time. You have a previous assault for domestic violence. It appears from your record from much earlier in life. But now we're back and we have another charge. And I think that 99% of the time I would take you into custody. Because I believe, and I'm not trying to make this a gendered statement, but if you were a male perpetrator, you'd be in custody. 100%. I have no doubt. Yet you and this gentleman continue to engage in conduct that involves law enforcement, assaultive behavior, and I'm just baffled. Whatever the source of this is something that you need to address in a very big way. Because my only remedy, because I am not a therapist, I'm not a mental health counselor, I'm not a doctor, is to say that you are taking the time up of law enforcement repeatedly within a very short period of time, ma'am. I'm not talking about months. Is this correct? This is 2 days? No, strike that. A month later,
Very close.
August. And then I don't know. This is one of those ones where you feel like they're going to be looking back on this because something else is going to happen to you two. And they're going to be looking back with that hindsight and saying, Judge, why didn't you do something? Because this now has come forward 2 times in front of you and you did nothing. And look what happened because of this.
Your Honor.
No, ma'am. Ma'am, I'm going to tell you that I am baffled at this circumstance. And I hope that if you're playing a role in this circumstance in any way, shape, or form, have any control over it, that you take some necessary therapeutic steps, whatever they may be, to de-escalate this situation.
I think I can enlighten you a little bit on the situation. I am the mom. And I'm
Please, you're not helping.
Thank you.
No, why don't you talk? Tell me what's going on here. What am I not understanding?
I'll tell you. Want me to stand up or sit down or am I fine?
You're fine right now. I can hear you.
So Mr. Treat doesn't want a no contact order.
I have 98% of my victims not wanting no contact orders. That's not novel to me.
I would like a no contact order. Mr. Treat can clearly do.
It doesn't work this way. I can give her a no contact order with him, but I can't prevent him from contacting her.
Okay, whatever it takes to keep them apart, because that's what we need.
If I put a no contact order in place, where does she live?
She lives in her own home. He lives with her. She has her own place.
Let's do it then.
Yeah.
That was not my understanding. So
Okay.
let's do it. Because I think there's a dynamic here.
Yeah. Let's get a no
Questionable on
contact
our
order. on it.
I'll fill it out.
Have a seat. We're gonna get some documents prepared. Let's, Chad, let's get this to Ms. Ward. She'll come out and talk to Mr. Andrus, but we're gonna get that figured out. Okay. I'm gonna call again the names of the folks that I have on for arraignment. If you hear your name, you need to raise your hand. You are late, but I'm glad you're here. Sarah Brown in the courtroom. Pedro Cohen is Pedro Cohen in the courtroom. Hang tight, sir. Paul Cole is Paul Cole in the courtroom. Jason Fulps is Jason Fulps in the courtroom. Bolivar Islas Campos is that person in the courtroom. Rick Langle. Mr. Langle's here. Pavel Mikhaliuk. It's Pavel in the courtroom. Deborah Sorensen. Sorensen's here. Austin Vernon. Austin Vernon's. Okay. Better late than never, folks. Thanks for showing up. We'll get everyone called here. Let's bring Mr. Cohen here first. Sir, if you could state your name and date of birth for the record.
It's Pedro Cohen, and then my birthday is 01/17/92.
Mr. Cohen, you're making a first appearance arraignment on 2 charges. The first is theft in the 3rd degree. That's a gross misdemeanor, subject to 364 days in jail and a $5,000 fine. The second is a controlled substance knowing possession charge, also a gross misdemeanor, subject to 180 days in jail and a $1,000 fine. I did review the associated police reports with your case. I did find what is called probable cause. Because these are criminal charges, sir, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened for a court-appointed attorney?
Yeah.
Okay, I'm going to ask you some questions about your income to see if you qualify. Do you receive any manner of state assistance at all?
I get food stamps.
I'm going to find you do qualify for a court-appointed attorney. Court will assign. Sounds good. Court will assign Brandon Campbell. Mr. Cohen, I'm going to enter a not guilty plea on both of your charges. That preserves all of your rights, keeps all of your options open. I'm going to assign 2 future court dates. The first is going to be on the 3rd of October, 2024. That is a date that your attorney, Mr. Campbell, can appear. It's not a required court date for you. Your next mandatory court date, sir, is going to be on the 17th of October, 2024. That is going to be at 10 o'clock in the morning. That is an appearance you need to be either in person or on Zoom, but you need to be present one way or another. Your release conditions are to violate no laws, appear at all mandatory court dates, notify the court of any change of address or phone number. You're not to have any contact with Walmart stores. I'm releasing you on your recognizance. I am also ordering that you cancel your warrants that you've had pending for years, it looks like, in the city of Vancouver. Do you understand? You need to go to the district court in Clark County and handle warrants. That's to be done prior to your next court date. Do you understand?
Yes, sir.
So Mr. Campbell can be in touch with you. Is there a phone number I can write on the form here?
Yeah, 971-517-2980.
Okay. We're going to get you some documents, sir, at the desk by the door. Once you have your paperwork, go to the same location where you checked in for court, where the glass partition is. There's a table on the left-hand side. It has business cards. Get one of Mr. Campbell's cards. Call his office. Let him know you've been assigned as his client, okay?
Thank you.
All right. Thank you, sir. Rick Langle. Morning, sir. Good morning. Thank you for contacting the court and letting us know you're going to be late. I appreciate that. Thank you. Mr. Langle, you're making a first appearance arraignment on a charge of driving while suspended in the 3rd degree. This is from January of 2020. This charge is a simple misdemeanor subject to 90 days in jail and a $1,000 fine. I have reviewed the police reports. I have found probable cause. Because this is a criminal charge, sir, you have several important rights, including the right to remain silent, the right to a speedy and public trial, the right to an attorney. Looks like you got a new driving while suspended. Would you like the court to assign you a public defender?
I don't believe I'm eligible for that.
Let's give it a shot. Do you receive any state assistance at all?
No,
Are you employed right now?
I'm retired, medically retired,
Okay.
disabled,
Can you
Parks.
estimate about how much you're getting per month after taxes?
1,800.
I'm going to find you do qualify for a court-appointed attorney. Court will assign Rebecca Ward. Based on the age of the case, sir, and it looks like you might need some assistance with navigating the DOL, I'm going to assign an attorney based on that, okay?
Okay,
Going to assign 2 future court dates, Mr. Langle. The first is a date on the 3rd of October that your attorney, Ms. Ward, will appear. It's not a required court date for you. Your next mandatory court date, sir, is going to be on the 31st of October, 2024 at 10 a.m. You can be in person or on Zoom, okay? But you need to be here that day. Your release conditions are to violate no laws, appear at all mandatory court dates, notify the court of any change of address or phone number. You're not to drive without a valid license and insurance. I am releasing you on your recognizance. We're going to get you some paperwork at the desk by the door. Yeah, I then want you to go over to the place where you checked in for court, where the glass partition is. On the left-hand side is a table with business cards. Get one of Ms. Ward's cards, give her office a call, let her know you've been assigned as her client, okay?
yes, sir.
Thank you, sir.
Thank you.
Oh, was it wrong? You may. Sorry about that. Oh, it's 2. Okay. I wondered about the pro se date and the attorney pretrial date was the same, and I got my answer. Sorry about that. Deborah Sorensen. Hello, ma'am. Making a first appearance arraignment, ma'am, on a charge of driving while suspended in the 3rd degree. It's a simple misdemeanor, subject to 90 days in jail and a $1,000 fine. I did review the associated police reports with the case. I did find probable cause. Because this is a criminal charge, ma'am, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened today, ma'am, for a court-appointed attorney?
Yes.
Okay, I'm going to ask you some questions about your income to see if you qualify. You receive any manner of state assistance at all?
Yeah, food stamps.
Okay, I'm gonna find you do qualify for a court-appointed attorney. I'm gonna assign Ms. Ward. Oh. Ms. Landwehr is keeping me on my toes today. Gonna assign Mr. Campbell. Gonna enter a not guilty plea, ma'am, that preserves all of your rights and keeps all of your options open. I'm gonna assign 2 future court dates. The first is gonna be an attorney pretrial date. That's gonna be on the 2nd of October, 2024. That's a date that Mr. Campbell will appear. It's not a required court date for you. Your next mandatory court date, ma'am, is going to be on the 17th of October, 2024. Sorry, yep, 2024 at 10 a.m. You can be in person or on Zoom, but you need to be here in some way, shape, or form. Your conditions are to violate no laws, appear at all mandatory court dates, notify the court of any change of address or phone number. You're not to drive without a valid license and insurance. I am releasing you on your recognizance. So Mr. Campbell can be in touch with you. Is there a phone number I can write on the form here?
Yeah, 360-916-3004.
Ms. Sorensen, I'm going to get you some documents over at the desk by the door. Once you have those documents, you are free to go.
Okay,
Thank you.
Thank you.
Austin Vernon. Hello, sir. Can I have you state your name and date of birth, please, for the record?
Austin Vernon, 9/9/2000.
Mr. Vernon, this looks like a failure to appear from November of last year. You
Yeah, I
were
was
supposed
very
to
confused on what that was on the failures up here because I showed up to my court date, got arranged for probation and everything. So I don't know if something wasn't taken care of after
Yep,
that.
That's where I'm going. You didn't do the 16 hours of community service.
I just totally spaced out. I apologize, Your Honor. In the middle of it, I was taking care of my grandfather in hospice and working 50-hour weeks. I had no excuse for that, but to apologize.
Were you in custody for any period of time?
I was not, Your Honor.
Okay, they just released you.
Yeah, and then I was charged driving a motor vehicle on Monday, and that's how I found out I had about the warrant, and I was booked and released. So I have another court date for that at Clark County on the 24th.
If I assign this or convert this over to 2 days of work crew, can you do 2 days of work crew?
Yes, sir, I can. I
That's
have
fine.
Wednesdays and Thursdays off, so if it could be one of those days, that would be amazing.
I'm gonna have you schedule that with the work crew chief. He should be here around 10. All right, so the same place you checked in for court after 10 o'clock today and before about 2 o'clock, you can come and ask to speak to the work crew chief. And he can get you signed up for the work crew.
And how will my second violation go on my next hearing? Will that be another date in here, do you know, or?
So the new charge is in a different jurisdiction. That is in Vancouver. So that's a district court in Clark County.
Okay.
On this case, as soon as you get the 2 days of work crew done, you're not going to have any further obligations to this court.
Okay.
Okay. So please expedite getting that done. So 16 hours ACS. I'm going to set a review about 2 months out. That's going to be November 21st.
Okay.
But again, the work crew should be done by then.
Yes,
right? You must do at least 1 day of work crew every 30 days. If more than 30 days pass and you've not done work crew, it gets returned to me and then it becomes jail.
So you know if I'll be able to just do 2 8-hour shifts for work crew and get it done on both my days off?
Mhm.
Yeah, thank you, Your Honor.
All right, so we're gonna get you some paperwork, Mr. Vernon, at the door. Like I said, it's about 9:30, so in about half an hour, work crew chief should be getting here. So if you want to hang around and wait, if you don't, be back anytime between 10 and 2. The court is closed and you're not going to be able to contact him between about noon and 1:30. So just try to plan
around, Your Honor.
accordingly, okay? All
Thank
right,
you very
thank you,
much.
Mr. Vernon.
One is Joseph Rodriguez, who would have been on for arraignment.
Okay.
It's a dismissal because EPA refiled with a companion case for this individual. District court needs for this dismissal.
All right, so Joseph Rodriguez, we had is 4A0747378. I have signed off on an order of dismissal without prejudice due to another jurisdiction filing, it sounds like. So, done that.
I have the agreed as
Right. Let's do that. All right, so Ms. Scar, come on up here. So our question is, if he's in her house, how are we gonna get him out?
What I did is order that defendant is to reside at, and I put in the center address. And I had two recommendations that I've given to Ms. Gaffney as far as there may be a reciprocal protection order request that the defendant puts in Clark County Superior Court. The other indication would be because our order indicates that per resident, she could have them. So those would be the two ways in which that could be enforced.
And he actually lives in Beaverton. He lives in Beaverton.
Anyway, Oregon.
He lives in Oregon.
So I think the thing that I worry about is that technically he can come to her address, not truly have a legal obligation not to be there. We can have law enforcement show up and she's like, I'm at home. And they're like, but look, he's here too.
So I think that is the best we can do in the circumstance, and less and until there's a civil protection order restricting residents.
And if we talk to mom about maybe helping with that, okay.
I talked to Ms. Gaffney, and I think that's better.
So that she could get a protection.
Can't give you any legal advice, ma'am, but that to me sounds like maybe the direction that we go, okay? All right. All right, Ms. Gare, so I'm gonna go ahead and sign off on this document here. NCO is going on the case number ending in 722. Please. Okay, so not guilty plea is going to be entered on the new charge. Again, that's 722. We're going to track that with 897. And it looks like the address that we have is getting, the mail is getting returned. Is it the address not on 279th Street?
No. It's my mailing address because she doesn't get the mail at her.
Oh, okay.
So
What's the mailing address?
2799 Northeast 61st Avenue,
Okay,
Battleground, Washington,
okay,
98608.
okay. Okay, that's the address the court will use. So let's see, we're gonna track this with our other matter. Other matter is set for next Thursday. So I'm gonna set these both to next week. So I'm gonna put both of your cases together, ma'am, so you're making just one court date on both of these matters, okay?
That sounds great. Good.
What I tell folks is, because this no contact order I'm gonna give you is 7 pages long, it has some legal terminology in it, is that if you have questions, whether what you're doing is okay or not, reach out to Ms. Gaffney. Ask her. She'll be a good resource to make sure you understand what you can and can't do. It may be also to protect your situation that you choose to go to another court and get a different kind of order. So you can be a little bit safer in your home.
Sure.
Okay?
Yeah.
We're gonna get you some paperwork at the desk by the door. Once you have it.
Okay, thank you.
Your
Your
Honor, thank you, Ms. Carmen.
Right. This is us. Yep, thank you. Yeah. Ms. Ward, are we ready on Mr. Watts?
We are, Your Honor.
Mr. Watts, can you hear the court, sir? Eric Watts, can you hear the court? Can I have you state your name and date of birth, please, for the record, sir? I got no audio of Mr. Watts. Hopefully it'll turn on here in a minute. All right, Mr. Watts, I think that audio is turned on. Can I have you state your name and date of birth again, please, sir?
Eric Michael Watts, 62575.
Thank you, Mr. Watts. I appreciate that. Your attorney, Ms. Ward, is with us here in the courtroom. It looks to me. Go ahead, Ms. Ward.
I apologize, Your Honor. Mr. Watts is making a first appearance on a new charge of no contact order violation, as well as a supervised release violation on his other case. We are going to be entering not guilty pleas at this point in time, waive formal reading. I believe that there's already a no contact order in place. Mr. Watts has been on GPS monitoring. So I don't think that the prosecutor's asking for an additional no contact order, just simply a condition. In this particular case, it looked like, she'll certainly correct me if I'm wrong. We are asking that the court consider release on this case, given that there is a no contact order in place and he is on GPS monitoring. If the court is not inclined to consider release, Your Honor, then we would ask to set this within the next couple weeks. If he's going to remain in custody, if the court is going to put bail, he's not likely to make any bail.
And just for the record, I did review the associated police reports with the September 6th incident. I did find probable cause for the charges. Not guilty plea is received. Ms. Carmi, regarding release for Mr. Watts.
Yes. Mr. Watts is being held on numerous other matters in Clark County. The combined bail bond is $7,500 on those. It is difficult. $7,500 is a fairly low bond for the number of DV protection order violations we now have. District court did release on recognizance where he's not currently being held on ours. While I don't necessarily have a concern about reappearance per se, if he's released, we know where he is. I do have concerns about the victim's safety. So I don't know if he's likely to bail. His next appearance on the district court matters is September 23rd. It looks like the felony matters were exonerated, but are also showing up as active. So I don't know.
So I'm assuming that if there were felony matters were exonerated, is there technically bail on those matters then if he hasn't appeared in district court yet?
So it just shows, I'm going to actually pull up the actual court proceeding here quickly because the jail record shows an exoneration and release right now. On the felony matters. Yeah, okay. So this does make more sense. It looks like he was on a diversion referral for the felony matters. Violation report was filed September 17th on that, but then prosecution canceled it. So I don't think he's being held on a felony. Jail records would support that. So I think the only bail in place is a $7,500 combined.
And is that on the 2023 misdemeanor protection order violations?
Yes.
Okay.
Mm-hmm.
And so our charge is not on the DCH, or maybe it was originally charged as Vancouver and then
it was there were
so we have two pending charges in Battleground. We have 3 pending charges in Clark County. And then looks like 2 unadjudicated felony charges also in Vancouver.
Right. And one of the district court charges does include escape in the 3rd degree. I guess I'm reluctant to stick with district court's position on no bail in our case. I mean, he could post 750, be out of there, and we have a significant history of protection order DV violations that I think causes concern for the alleged victim.
So what's the city's position?
Well, I think in our case, I would ask for at least an additional 3,000 bail. I think that would put what he would have to tender to jail up to $1,000, which is, I think, more realistic. I do believe that the civil protection order that underlies these cases is still in effect. It is an active NCO, so we're not asking for a standalone.
I'm going to articulate what my concern is. So if my recollection on this case is correct, the June incident. Now, let me turn back.
Yeah.
I want to make sure I'm being accurate, not misremembering things. Okay, yeah, this is what I thought. So here's why I'm going to do what I'm going to do. The allegation is a violation that was taking place at this protected party's place of work. So very clearly from back in June, Mr. Watts had some knowledge as to where this protected party was working. The new allegations are him basically hopscotching back and forth right in front of the work or within 1,000 feet of the work, the same place that the protection order violations had taken place 3 months before. This is not a circumstance where he didn't have knowledge. This is not a circumstance that wasn't the exact same place that 3 months ago he had had the protection order violation levied from. So I am going to find this as new conduct. I'm going to find this as concerning conduct, and I'm going to find this as conduct that he had full knowledge of based on when he was last charged. So I'm going to impose bail in the amount of $3,000. Based on that, Ms. Ward, where do you want the case now set to?
I would ask that we just set this over a couple weeks, Your Honor. He's not likely to make any bail. So I will get with the prosecutor to see if we can reach some sort of global resolution on this. If we can't, then we will be back in front of the court in a couple weeks, setting trial dates within in custody.
All right, so let's set out maybe, do we have Ms. Ward, are you going to be here in 2 weeks perhaps? Could we set this out to October 3rd?
Sure.
All right, we'll set this out to October 3rd. 2024. Mr. Watts, if you post bail, you need to be here at 10 a.m. on October 3rd for a mandatory court date. If you are still in custody, sir, you'll be brought over from in custody. If you do provide or post bail, your release conditions are to violate no laws, appear at all mandatory court dates, notify the court of any change of address or phone number. I am placing Mr. Watts on intensive pretrial release based on the fact that we're back with the same conduct again while he's on release on the same charge with the same victim in the same location. All right, Mr. Watts, that concludes your hearing. Thank you, sir.
Thank you, Your Honor.
Mr. Campbell?
Yes, Your Honor, we have the Ty Smith matter ready. It's in custody.
Okay. Mr. Smith, can you hear the court, sir?
Yeah,
And have you state your name and date of birth, please, for the record?
Ty Russell Smith, October 20th, 1994.
Okay. All right. All right, so Mr. Smith is making a appearance today.
After an evaluation
After
and
the
restoration
evaluation.
period up at Western State Hospital, Your Honor, and I'm not sure if you've had an opportunity to review the report, but I believe both the city and the defense are in agreement that the report finds that he's currently incompetent under both prongs of 1077. There isn't actually any information in the report that I was able to review, and I did read it a couple times, indicative of anything other than they are requesting a DCR evaluation. I haven't done a DCR order in some time, and so I put a sticky note there. I believe that it's the practice of the jail to transport people to Peace Health, so that's what we put down. but I also am not positive about that. So I'll just defer to your honor in that regard relating those findings. I was hopeful that we'd have a forensic navigator here today to give us some information about these things. For example, I've spoken with the client and I'm just reiterating this for the record to get his medications. He can ask for a prescription from the jail and they give him, as I understand it, a piece of paper that he then takes to Walgreens and they'll give him some medications for the next few days. But it just seems to me that there should be someone from DSHS to help him get to his next place, to have any hope that he won't be back here. But this is where we're at. So we're asking for a dismissal and a DCR evaluation.
I have signed off on the documents. So Mr. Smith, Mr. Campbell has provided you some good information. Our hope is that the jail folks or folks from DSHS can help you get some guidance on kind of what the next steps look like, sir. But the court doesn't necessarily have jurisdiction to tell you those things, just hopefully point you in the right direction. Do you have any questions, sir, about court today?
No.
Okay,
And
good
Your
luck.
Honor, I would like
Oh,
to
go ahead,
hand
Ms.
up-
Carmen.
I'm just adding date of birth on here. The ineligibility to possess firearms due to a dismissal for reasons of mental health. So I'm just filling out the last parts of this.
So Ty, the prosecutor and the judge are going to be entering an order that prohibits you from having any firearms or under federal law firearm ammunition.
Okay.
And then you have to ask the jail for your prescription list to be able to get it, to take it to Walgreens.
I think they gave, or Western State Hospital gave me 2 prescription bottles or something like that.
Well, let's hope so. If they've got your medicines and they're releasing them with you, great. If they do not give you medications when you leave and your personal property, you need to advocate for yourself with the jail staff and tell them you need a prescription. Otherwise, you can also try calling my office and we can help with that if you want.
All right, I did sign the order of ineligibility to possess firearms and have added that to the file as well. Good luck, Mr. Smith.
And I'm not sure if you're ready for 10 o'clock matters, Your Honor, but I do have a dismissal. It's pretty short. Ready to go?
Dismissal, that's pretty short.
Alex Cooper Smith is making ready for custody. It's a conflict basis. And I know that Mr. Busby's not here, but it's already been filled out and signed, so I think we're good to go. Should be signed, is it not? Oh, what time is it right now? We're gonna have to wait till Mr. Busby gets here.
Yeah.
Sorry, Judge. I thought it was ready to go. I have an email, but I don't.
So tell you what, I can sign it right now.
Okay.
If you would just have Mr. Busby sign it before you file it. That way you're not gonna have to recall the matter.
Thank you so much. The client will appreciate it. Thank you.
Do you want to hold on to the court file then? Maybe
Well,
put it where Mr.
absolutely do so.
Busby's
Do my
gonna be?
best not-
All right, good luck. Thank you.
Alex, you're good to go. You can get a copy of this. Need a copy of this order from 30 days.
Pavel Mikhaliuk. May I have you state your name and date of birth, please, for the record?
Pavel Mikhalik, 01/06/1995.
Where were you this morning?
Very good. How are you?
Where were you this morning?
Went to district court.
Gotcha. That happens from time to time. Mr. Mikhalik, you're making a first appearance arraignment on 3 charges. The first is DUI. DUI is a gross misdemeanor. It's subject to 364 days in jail and a $5,000 fine. It's also a charge that has mandatory minimum jail sanctions that's based on the existence of previous DUIs or cases that started as DUIs that were amended down. Your second charge is reckless driving. Reckless driving is also a gross misdemeanor, subject to 364 days in jail and a $5,000 fine. That charge carries mandatory license suspension and the requirement for what's called SR22 insurance. The third is driving while suspended third degree. It's a simple misdemeanor, subject to 90 days in jail and a $1,000 fine. I have reviewed the associated police reports with your case. I have found probable cause on all 3 charges. Because these are criminal charges, sir, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, right to an attorney. Would you like to be screened for a court-appointed attorney?
No, I got an attorney,
Who is your attorney?
Aaron McLaren.
Aaron McAleer.
Oh, McLean, yeah.
Where's Mr. McAleer?
He's not here. today.
Going to be here today?
I just got him the other day.
You hired Mr. McAleer to
Yeah.
represent you. He hasn't filed any documents. When did you hire him?
The 13th, I have to go sign another paper at his office.
Your Honor, you want me to reach out and see if there can be like after
Yeah. Well, I mean, release conditions are statutory, whether they're here or not, we're gonna set release conditions, so. All right, have a seat. We're gonna figure out if your attorneys are gonna be here.
I'm gonna go over the carpenter materials before I put it closer. You don't want to take a guilty plea?
Take anything that's ready.
John. And what, all day, you know?
So, Mr. Carpenter, it looks like what is proposed today is for you to enter a plea to a charge of assault and fourth degree non-domestic violence. Is that your understanding?
Yes.
You had plenty of time to talk to your attorney, Mr. Campbell.
Yes.
You need any additional time?
No.
Mr. Campbell, none of this is signed unless I have multiple copies.
Oh, Your Honor, I had a separate photo over here for you today. For file, I should say. It was executed, but I left that file at the office. Then sign right there. Go.
All right, so Mr. Carpenter, you are 37 years old. You've completed the 12th grade of school. Is that correct?
Correct.
Are you able to read and understand the English language?
Yes.
Entering a plea today to the charge of assault in fourth degree, you are giving up some important rights on your case that we're going to review on the record. You have the right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed. You have the right to remain silent before and during trial, and you have the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you. You have the right at trial to have witnesses testify. Witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty, and you have the right to appeal a finding of guilt after trial. You understand those rights, Mr. Carpenter?
I do.
And you understand that in entering a plea today, you're waiving or giving up those rights.
Yes.
The charge that you are pleading to today is what is called a gross misdemeanor, subject to 364 days in jail and a $5,000 fine. There is a pretrial agreement. You understand the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law.
Yes.
The court can place you on probation for a time frame of 2 years, during which time you'd pay cost, fees, and assessments as authorized by law. The charge of assault in the fourth degree taking place on August 11th, 2023 in the city of La Center, Washington. How do you plead?
Guilty.
Are you entering this plea freely and voluntarily?
Yes.
Has anyone made any threats or promises to get you to plead guilty?
No.
Factual basis states on or about August 11th, 2023 in the city of La Center, Washington, I did intentionally touch another person in a fashion a reasonable person might find offensive. Is that a correct statement?
Correct.
I will accept the plea, find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. What's going to happen now, Mr. Carpenter, is I'm going to briefly hear from the city attorney, Ms. Carney. I'm then going to hear from your attorney, Mr. Campbell, and you'll also have the right to talk to me before sentencing. Go ahead, Ms. Carney.
Yes, Your Honor, we're asking the court to follow the recommendation. This is a unique case in that both parties have CPOs against each other. We're not asking for a post-conviction NCO because of that. We would otherwise ask you to follow the recommendation.
Mr. Campbell.
And Your Honor, Mr. Carpenter has been before this court previously on DV matters that you can see associated with prior dismissals. Those were dismissed via stays. In those cases, he did a 52-week DV perpetrators program and coursework. You know, there is a complex family dynamic at issue in this case. And I've even spoke with my client a little bit about some of the concerns that, you know, looking at this resolution, it may not seem on its face to be prudent, but we're asking to impose those conditions as outlined. It's been a heavily negotiated case. It was a matter that was really tracking towards trial. Lots of investigation has gone into this matter. The parties have 7 children together. My client currently lives, the no contact order was previously terminated. There's a bunch of carve outs in the DV protection orders that were mutual restraining orders that were put in place in a civil case that was kind of that resulted as basically in the context of the investigation that Your Honor is taking a plea on right now. Other attorneys were involved in that negotiation. That negotiation resulted in my client having sole custody over some of the children that are at issue in this case and having 50-50 custody of other children that are associated with this case. And then having less contact with some of the other littler children that are staying primarily with my client often during the day and then with mom at night. My client certainly engaged in behavior in this instance that he's taking responsibility for. He has been told basically that the relationship between he and Kate Carpenter isn't such that they can ever be in the same home again and it'd be safe for my client. He has been charged now numerous times with assaulting Kate, and I'm not saying that he's a bad person because of that. What I'm saying is that he has to make smart decisions moving forward. He's done so. Their families are separate at this point, but still together because of the children. In this instance, my client was leaving for a fishing trip, leaving some young children with his wife, who he thinks has some sizable mental health concerns. And I don't say that to be disrespectful, but he was worried about her being upset that he was leaving. They were living at separate parts of the house at the time. And, you know, there was an interaction between the two that was inappropriate. He's taking responsibility for that. I think if we had gone to trial, there would have been a self-defense claim. I mean, none of the children were interviewed. There's a complex case because of all these factors, because my client isn't proceeding with trial, and because of the fact that there has been a lengthy period of cooling off. We're asking that you impose 5 days of work crew. You know, my client, any day, for example, that he was in jail, he's paying for both houses. The mortgage is on both homes right now. And
the financial circumstances.
Yeah, I mean, the financial circumstances are dire. He makes more than the indigent amount, but he's got 7 children and he's maintaining 2 homes. How much do you make per month?
About 8,000.
And then how much do you think your bills are? How much money do you have left over after bills every month?
I have to work some overtime to make everything work.
So, I mean, he's maintaining 2 full mortgages and 2 full households at this time on his single income. His wife can't work because they have 7 children. I mean, it's a really tough situation for everyone to be in. Jonathan's very aware that he's going to have a relationship with Kate moving forward, and he needs to protect himself in only having communications with her with other adults present during those communications when they're in person and otherwise in writing. And that's been working over the past almost year and a half that this case has been pending. So, John, did you want to tell the judge anything or no?
It's a challenging dynamic. my 1-year-old was sick. Kate needed a break. She was at my house last night, up 3 times.
The 1-year-old.
Yeah.
Yeah.
So I mean, it's not like I'm doing, I feel like, an excellent job co-parenting and providing for everybody and creating stability for the kids. And we have some behavioral challenges with the one child in particular, but potentially a couple. And like, I'm the one that works with the school and coordinates the challenging aspects that arise. So it's kind of a tough dynamic.
And he is the sole parent of 2 of the children, the 15-year-old and the 11-year-old.
Full time,
Yeah.
100% of the time, and one does daily visits with mom and the other
Oh,
one doesn't.
the other thing I should mention is I believe the mother has actually filed a restraining order against one of the children. So if my client, I'm not trying to say this as a, it's just a further factor that came into the negotiated settlement agreement. If my client was to go into custody, CPS would then have to take the child and put him into shelter care. He's not having any communication with his mother at this time.
Right, I'm gonna follow the recommendation of the parties. It's 364 days in jail with 359 days suspended, leaving 5 days to serve. Same place you checked in for court, Mr. Carpenter. Go over there today, ask to speak to the work crew chief, get signed up for work crew. You must do at least 1 day of work crew every 30 days. 30 days pass and you have not done work crew, it gets returned to me. It can be converted to something else, so please do your work crew. We have $5,000 fine with 4,900 suspended, leaving a $100 fine to pay. To that will be added a $30 work crew fee, a $43 conviction fee, a $300 public defender recoupment.
Oh, Your Honor, this is a retained case. I'm sorry to interrupt.
Strike the public defender recoupment. So a total financial obligation then of $173. No law violations, bench probation for 24 months. Conditions to be added, a mental health evaluation and comply with any recommended treatment. Mr. Carpenter, we are setting a review date for December 19th, 2024 at 1:30 p.m. That is a mandatory court date. At that time, we'll be reviewing your mental health evaluation, any recommended treatment, and your progress on work crew. Do you have any questions at all about your sentence?
No. I just had one. Am I here on the 19th
December?
of December? Yes, I'm sorry. Perfect. That'll work great.
All right, we'll get you some documents, Mr. Carpenter, at the desk by the door, then go talk to the work crew chief.
So,
Thank you.
Get that work here knocked out. Thank you, Your Honor. I have a couple other matters that are very shortly going to be ready, but I just need to step off and make them so.
Did you hear from Mr. McAleer's office?
Nothing.
All right, Mr. McAleer, come back up. All right, we've reached out to your attorney's office. We haven't heard anything. I'm going to go ahead and proceed to the arraignment. I'm going to enter a plea of not guilty on all 3 of your charges. That's going to preserve your rights and keep all of your options open. I'm going to assign 2 future court dates. The first is going to be an attorney pretrial date. That's a date that someone from the law firm would make an appearance to discuss your case with Ms. Carmi. That is going to be on October 2nd, 2024. Your next mandatory court date, sir, is going to be on October 31st, 2024. That is going to be at 1:30 in the afternoon. That is a mandatory court date, sir. You can appear in person that day or on Zoom, but you do need to be here for court. Ms. Carmi, regarding conditions of release.
Yes, Your Honor, we are noting a very recent 2023 DUI pled down to reckless, no other out-of-state history. We do note this was a blood draw. As such, we don't know at this point what VAC may allegedly be. Out of abundance of caution for community safety, we are asking for standard DUI conditions in addition to scram.
Mr. McCallie, following your release conditions, you are to violate no laws. You're to appear at all mandatory court dates. You're to notify the court of any change of address or phone number. You're not to consume or possess any alcohol or non-prescribed drugs or controlled substances. You're not to drive without a valid license and insurance. You are going to be placed on a 24/7 scram monitor. through administrative pretrial release at Clark County Pretrial Release. You were to have the Scram monitor around your ankle in the next 5 business days. I have put a arrow to the phone number for pretrial release. You need to give them a call and get the Scram device on. Do you understand?
Okay.
We're gonna get you some paperwork at the desk by the door. Once you have your documents, you are free to go. Thank you. I'm gonna recall the arraignments. I think we had one other arraignment person show up. Sarah Brown, Paul Cole, Jason Folks, Bolivar East Los Campos. Nope. Which one? Paul Cole, come on up, sir. If you hear your name called, we had you scheduled at 8:30 this morning.
Yes, sir. I had to ride.
Understand.
I had to ride my bike out here.
Okay. So Mr. Cole. All right, so Mr. Cole, you have a pending charge protection order violation from March 16th, 2024. It's a gross misdemeanor subject to 364 days in jail and a $5,000 fine. That case has been on warrant status since May 2nd with bail. We also have tracking warrant cases. It's like these matters are post plea, an assault in the 4th degree case. Where work crew was assigned and another charge.
Your Honor, I just recently, a month and a half ago, came back to Vancouver. I've been living in Portland and I was working in Portland. I never came over into Vancouver at all.
We have court on Zoom, sir, so.
Well, no, I mean, for that last, the breaking of the no contact order.
It's your new charge. You have a right to remain silent. You say it can be used against you, so I would advise you to remain silent, not talk about your new charge.
Yes, sir.
The incident date on the new charge, for your information, is from March of 2024. So because that is a criminal charge, sir, because you have important rights on the case, you have the right to a speedy and public trial by an impartial jury. You have the right to an attorney. Would you like to be screened for a court-appointed attorney?
Yes, sir.
I'm going to ask you some questions about your income to see if you qualify. Do you receive any manner of state assistance at all?
Yes.
What's the nature of the assistance?
Huh?
What type of assistance do you get?
Medical and food stamps.
We'll find you do qualify for a court-appointed attorney. Court will assign. Mr. Cole, I'm going to ask that you have a seat so you can talk to Ms. Ward before I call you back up to finish your arraignment, okay? Thank you, sir. Okay. Chad, can you give these to Rebecca? This gentleman's here for a minute. All right, Ms. Winter, can you hear the court, ma'am?
Yes.
Thank you, ma'am. Can you tell me your name and your date of birth, please?
Kimberly Winter, August 25th, 1992.
Ms. Winter, you're making a first appearance arraignment on a charge of violation of a domestic violence no contact order. That charge is a gross misdemeanor, ma'am. It's subject to 364 days in jail and a $5,000 fine. I did review the associated police reports. I did find probable cause. Your attorney, Ms. Ward, is with us here in the courtroom. Go ahead, Ms. Ward.
Yes, Your Honor, we're entering not guilty pleas on the no contact order violation as well as possession of controlled substance. We're asking to waive formal reading and set those over in the normal course. We are asking for release on our own recognizance in these cases, and I'd like to be heard regarding release at the appropriate time.
Ms. Carmi, city's position.
Yes, Your Honor, there is an active no contact order that was put into place from a Clark County District Court, the one ending in 968. Obviously, as a condition of this, of any release, regardless of bail or not, we are asking that remain. There isn't, it's just going to pull it up. This one just came in this morning. There's only one failure to appear in the history here, which is from March of 2024. My understanding is that the defendant may be pregnant at this time. So I think all things considered, what we would ask for, because there is a history of DV here with the same victim, that there be enhanced pretrial release contact. So we can, I guess, know Ms. Winter's whereabouts at times. We would ask for a condition of no use of controlled substances. Because of what I understand is the dynamics right now, we would ask for random UAs to be imposed that could be monitored by pretrial release. Otherwise, we are not asking for bail to be put into place.
And Your Honor, we're not objecting to the no contact order. My client does have a separate residence from the alleged victim. We've filled that in on the return to court form. She is living there with a friend. She just recently became employed, and she is hopeful that she will not miss work. The prosecutor is correct. She is pregnant. She actually has a prenatal appointment today. We would object to random UAs and enhanced release at this point in time because it is going to present problems for her with respect to the job as well as making doctor's appointments. That is something that's currently being monitored by the doctor's office. We would ask for release on her recognizance at this time.
I will just note, well, go ahead, Your Honor. I apologize.
So Ms. Winter, I think the court has some concerns on a number of levels, just based on, it looks like some of the statements that you made. Certainly things like smoking marijuana when you're pregnant, not a good idea. Possessing allegedly methamphetamine, worse idea. So I am going to follow, I suppose, what both sides are saying. I am going to release you today. Your next mandatory court date's October 31st, 2024 at 10 a.m. Your release conditions are to violate no laws, appear at all mandatory court dates, notify the court of any change of address or phone number. You're not to consume or possess any alcohol or non-prescribed drugs or controlled substances. You're not to have contact with Adam Shelton, date of birth April 30th or April 20th, 1973. I am going to impose random UAs. I think that any of the medical providers would say as well that random UAs maybe is the thing that will motivate you to not be using drugs, alcohol, or other things while you are pregnant. I'm going to place you on administrative pretrial release. You're going to be contacting them within 24 hours. They're going to set you up on what's called a Keller line. If I have any indication, ma'am, that you're using drugs, alcohol, or other controlled substances during your pregnancy in this court release, I am going to be placing you back in custody. Do you understand the court's orders?
Yes, sir.
All right. We're going to be getting you some documents over at the jail. Once you have your paperwork, you are free to go wherever they tell you. Thank you. Ward, I have a whole stack of your files up here. So
I
you
was
wanna
just going to say,
start, sounds good. All right.
You just want to call what you have in front of you.
Well, I'm assuming there's some short ones and some long ones. So I'm going to try to go through and find a couple of shorter ones. I don't see very many of them. Maybe we could call the Hernandez Sandoval case.
Let him come forward. Your Honor, my client's in the process of trying to reinstate his license. With that in mind, we have handed forward a waiver of speedy trial as well as a set over. Hopeful that we will come back before the court with his driver's license in hand, Your Honor.
Mr. Hernandez Sandoval, were you able to talk to Ms. Ward about your right to speedy trial?
Yeah.
You understand that in doing a waiver beginning November 21st, you're giving the city of Battleground 90 days from that date. It becomes necessary to bring you to trial. Are you in agreement with that?
Yeah.
We'll accept the waiver. I'll find it knowing, intelligent, and voluntarily made. Your next court date's November 21st at 10 a.m. We're going to get you some paperwork, sir, at the desk by the door. Once you have your documents, you are free to go. So, means if we have Cole Lewis as well as a court
I
member.
believe to be on Zoom, Your Honor. Is he on Zoom yet?
Not current.
Yeah. I
Oh, no,
believe he-
Cole Lewis is, I think, yeah, Cole Lewis is on Zoom. Mr. Lewis, can I have you turn on your camera, please, sir? Well, he is here. See, his hand is raised. Mr. Lewis, I need you to turn your camera on for us to have your court hearing, sir.
Is that working?
Your camera's on. Can you say your name and date of birth, please, for the record?
Yes, Cole Lewis, 5/4 of 1982.
Go ahead, Ms. Ward.
Your Honor, similarly, he is trying to get his license reinstated. He had a failure to appear that he had to clear up, I believe, up in Cowlitz County. I did receive proof that he had attempted to get that failure to appear cleared up. We have entered a waiver of speedy trial and a set over to accommodate, hoping that he will have his license in hand the next time he comes to court, Your Honor.
Mr. Lewis, were you able to talk to Ms. Ward about your right to speedy trial?
Yes.
You understand that in doing a waiver October 31st, you're giving the city of Battleground 90 days from that date. Are you in agreement with that?
Yes, sir.
All right, we'll accept the waiver, find it knowing, intelligent, and voluntarily made. Mr. Lewis's next court date's October 31st at 10 a.m. We're going to mail you some paperwork, sir. Are you still getting your mail on 10th Street in Battleground?
Yes, sir.
All right, we'll mail the paperwork there. If there's nothing further, you can log out.
I'm still showing that Cowlitz district.
Thank you.
Yep.
Oh, so it just hasn't taken it out. Thank you. Okay.
You know Malcolm Ricks?
I believe he was going to be online, Your Honor,
Yep,
as well.
he's there. Mr. Ricks, can I have you? There we are. Can I have you state your name and date of birth, please, sir?
Yes, sir. Malcolm Ricks, and then my date of birth is 10/4/1993.
Thank you, Mr. Ricks. Have Ms. Ward here. Go ahead, Ms. Ward.
And Your Honor, he just simply needs to make a payment and he's able to reinstate his license. We're asking just for a very short 3-week set over just to allow him to have the opportunity to come up with those funds.
All right, Mr. Ricks, did you talk to Ms. Ward about your right to speedy trial?
Yes, Your Honor.
You understand doing a waiver on October 10th gives the city of Battleground 90 days from that date if it becomes necessary to bring you to trial. Are you in agreement with that?
Yes, Your Honor.
All right, I will find it's a knowing, intelligent, and voluntary waiver. We're going to see you back here October 10th at 10 a.m.
Yes,
Please
sir.
stay in touch with Ms. Ward. We're going to mail you some paperwork. Is your address still on Fruit Valley Road, Apartment B?
Yes, Your Honor.
All right, we're sending some paperwork there, sir. You can log out. Thank you.
Thank you.
Your Honor, I think we had a Harold Andrus that
Yep.
was making.
When I was at next. Mr. Andrus, come on up with Ms. Ward.
Your Honor, Mr. Andrus is making a new appearance on a new charge of no contact order violation. We'd like to enter a not guilty plea on that charge, Your Honor. Waive formal reading and set over to October 17th to track with his other case. I'm hoping that we can reach some sort of global resolution.
All right, Mr. Andrus, I'm going to enter a not guilty plea on the new charge. That's cause number 4A0727159. That matter is going to track, meaning it's going to appear at the same court date as your other matter on October 17th at 10 o'clock in the morning. Ms. Carmi, in regards to release, it looks like a condition of release is the continued no contact order between he and Ms. Andrus.
That is correct. I will note, district court had put intensive pretrial release. I think the court caught that when it came in, and we would just ask for him to remain on the pretrial on the previous matter so that we're not doing pretrial release on both cases.
Okay, so the random UA condition is going to be continuing just on the case ending in 598.
Correct.
So you remain on the random UAs that have been previously ordered on the other case, but not additional on this case, okay? But you can't have any direct or indirect contact. We talked about that, and keep doing what you're doing with your counselor, okay?
With my PO and
Yep.
and with you.
Absolutely.
Good.
Okay.
All right, Mr. Andrus, we're going to get you some paperwork, sir, at the desk by the door. Once you have your documents, stay in touch with Ms. Ward, okay?
Thank you, Your
Thank
Honor.
you, sir.
Thank you.
Well, right over here.
All right, Ms. Ward, keep going. You want to do Clarissa Cox?
Yep, Clarissa Cox. Your Honor, this is a stay of proceeding to a charge of possession of a controlled substance. Ms. Cox is coming forward. We've gone through that. I believe she understands it, and we are wanting to enter that at this time.
Ms. Cox, these stays of proceedings I'm not a party to. This is a contract between yourself and the city of Richfield. My job is to make sure you understand the terms, and if you do the things you're supposed to do, your case gets dismissed. So let's talk about what they're asking you to do. There are some costs, fees, and assessments, a filing fee of $150, a supervision fee of $150, and a $300 public defender recoupment. So over the year, it's a total cost of $600. You can do that on a payment plan. You are to get a substance use evaluation and comply with what they recommend. Not to have any new criminal charges, here at all future court dates. You are giving up some important rights and entering the stay today. You are giving up your right to jury trial. Do you understand that right?
I do.
You're also waiving your right to speedy trial, with speedy trial beginning again a year from today on September 19th, 2025. Do you understand that right?
Yes, I do.
Any agreement with that waiver?
And
Right. Charge which you are entering your stay on is a gross misdemeanor, but it's actually subject to a 180 days and a $1,000 fine. I'm just going to modify that in our form here.
I apologize.
That's okay. Not a problem. So Ms. Cox, any questions for Ms. Ward or for myself before I sign the document and enter you into the stay?
No.
Okay. So I'm going to see you next, Ms. Cox, on the 19th of December. At that time, I'll be looking at the substance use disorder evaluation and looking forward to hearing how treatment's going, okay?
Okay, perfect.
We're going to set a final court date for September 18th of 2025. At that time, if things have gone well, your case gets dismissed.
Perfect.
Okay.
Okay, cool.
I'm going to get you some paperwork at the desk by the door. Thank you, ma'am.
You have Taylor Turk, Your Honor.
Yep, Taylor Turk.
Your Honor, similarly, I believe that I filled in the maximums inappropriately. I did go over where them with her appropriately. If you could just simply line those out and
Yep.
insert the 180 days and $1,000 fine, Your Honor, I'd appreciate it. Thank you.
Sure. So Ms. Turk, similar circumstances here. Again, the court's not a part of this. This is a contract, in this case, between yourself and the city of Battleground. My job is just to make sure you understand the terms. There are some financial obligations in regards to $150 filing fee, $150 supervision fee, and a court public defender fee. That's total costs of $600 that you can do a payment plan for. You are to get a substance use disorder evaluation and comply with any recommended treatment, not have any new charges, and appear at all court dates. Again, you are giving up some important rights in regards to your jury trial right and the waiver of speedy trial. Do you understand those rights?
I do.
And in regards to speedy trial, are you okay with beginning that speedy trial September 19th, 2025?
Yes.
Fine, it's a knowing, intelligent, voluntary waiver. The charge which you are entering on is a maximum of 180 days in jail and a $1,000 fine. Ms. Turk, any questions at all for Ms. Ward or for the court before we enter you into the stay?
Yeah.
Okay. We're going to see you back here on December 19th. That time I'll be looking at the substance use disorder evaluation and checking in to see how treatment is going. If everything is going well, on the 18th of September, you get to come back and have your case dismissed. So we're going to get you some paperwork, ma'am, at the desk by the door. Once you have that, you are free to go. Thank you.
Anna Karas.
You have an attorney?
Yep.
Yeah, you need to get
Anna?
back to her. Nope, you need to talk to your attorney.
Hello, ma'am. Can I have you state your name and date of birth, please, for the record?
Anna Karas, 8/18/1960.
Ms. Karas, you are entering a stay as well today with the city of Richfield on 5 theft in the third degree charges. Have you been able to go over the stay agreement with Ms. Ward? I need to have you answer out loud.
Yes.
Okay. Do you have any questions about the agreement so far?
You have to answer out loud.
Okay. This is a contract, as we talked about, between yourself and the city. There's some specific things that you have to do. There are some fees and costs in the amount of a filing fee of $150, a supervision fee of $150, and a public defender recoupment of $300. So that's total cost of $600. You are also to make restitution to Rosars, in the amount of $424.42. That is to be paid by the end of your stay. Okay, so you need to make sure you have proof of that payment being made. You are to maintain compliance with the
By the end
payment.
of the 12-month period of time.
You're to maintain compliance with the payment plan for the court. You're not to have any contact with Rose Hour stores. You're not to have any new charges. You're to appear at all court dates. You are getting credit for 2 days that you served in custody. You're giving up some important rights in entering your stay agreement today. You're giving up the right to a jury trial. Do you understand that right?
Yes.
You're also doing a waiver of speedy trial with speedy trial beginning next year on September 19th, 2025. Are you in agreement with that?
Yes.
Fine, it's a knowing, intelligent, and voluntary waiver. Each of the 5 charges carries 364 days in jail and a $5,000 fine. Do you have any questions, ma'am, for Ms. Ward or for the court before I sign this agreement to enter you into the stay? Okay. I am going to see you next on December 19th, 2024. At that point, we'll be reviewing the restitution. We'll also be looking at, I think it primarily is going to be just the restitution. We'll be verifying that restitution. The final review date is going to be on the 18th of September, 2025. That's going to be at 1:30. So Ms. Karas, we're going to get you a copy of this stay document. Once you have it, you are free to go. Thank you, ma'am.
I don't. I have some matters ready. if you
Justin
need
Campbell.
Justin Campbell?
a respite though. Or I'll just keep getting stuff ready.
Your Honor, this is going to be a guilty plea to 1 count of operating a motor vehicle without ignition interlock device and that's count 2 on the charge. Count 1 will be dismissed per the plea agreement.
You are Justin Michael Campbell.
Yes, Your Honor.
You're 28. You've completed the 12th grade in some college. Is that correct?
Correct.
Be able to read and understand the English language.
Yes.
In entering a plea today to the charge of operating a vehicle without an interlock device, you are giving up some important rights on the original charge of driving while suspended and that charge. You have the right to a speedy and public trial by an impartial jury in the county where the crimes alleged to have been committed. You have the right to remain silent before and during trial and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you. You have the right at trial to testify and have witnesses testify for you, and witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty, and you have the right to appeal a finding of guilt after trial. You understand those rights, sir?
Yes, sir.
You understand that in pleading guilty today or waiving or giving up those rights. The charge that you are pleading to is a gross misdemeanor. It is subject to 364 days in jail and a $5,000 fine. There is a pretrial agreement I'm holding up. Do you understand the court does not follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law?
Sure.
The court can make you pay cost, fees, and assessments as authorized by law. This is also a circumstance that box L is checked. Box L specifically talks about that this adds 6 months to any existing interlock term you have with the Department of Licensing after whatever that term is. Do you understand that?
Yes, Your Honor.
And you're saying that's a mandatory condition that I can't choose not to impose.
Yes, sir.
To the charge of operating a vehicle without an interlock device taking place on July 11th, 2024 in the city of Richfield, how do you plead?
Guilty.
Are you entering the plea freely and voluntarily?
Yes, Your Honor.
Has anyone made any threats or promises to get you to plead guilty? Factual basis states on or about July 11th, 2024 in the city of Richfield, state of Washington. I operated a motor vehicle without an ignition interlock device, knowing such device was required to be installed and operational in any vehicle I am operating. Is that a correct statement?
Yes, sir.
I will accept the plea. I'll find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. I'm going to hear now from the city attorney, briefly from your attorney, Ms. Ward, and you'll also have the right to talk to me before sentencing. Go ahead, Ms. Carmi.
Yes, Your Honor, we would ask you to follow the recommendation. Obviously, we're asking for some affirmative condition, but as Your Honor noted, this will add to what is already a somewhat lengthy still requirement for interlock. So with that, we would hope the court would follow the recommendation.
Ms. Ward?
Your Honor, can you permit me just a moment? I have my notes regarding we're in agreement with the recommendation, but for the financial portions.
Sure. You can confer with your client.
Thank you. Okay, anything else that I forgot from yesterday? Okay. Your Honor, we are in agreement with the recommendation, but for the financial portions, he is not currently employed. It's been quite a few months since he's been employed. He's currently living with his aunt, relies on her for day-to-day needs. He is in the process of applying for food stamps. And he has fines and fees and collections in the thousands. Anything additional that Your Honor imposes is going to be unduly burdensome. He's already going to have an additional 6 months of the ignition interlock once he's able to get that reinstalled.
Mr. Campbell, anything you'd like me to know?
But she's said majority of it, yeah.
I'll follow the recommendation of the parties. It is 364 days in jail with 354 days suspended, leaving 10 days to serve on work crew. You must do at least 1 day of work crew every 30 days. If 30 days pass and you've not done work crew, the case gets returned to me. Same place you checked in for court where the glass partition is over here. Go over there and ask to talk to the work crew chief and get signed up for work crew today. I am going to find pursuant to the Blazina analysis that Mr. Campbell is indigent. It'll be a $5,000 fine with all 5,000 suspended. No fines, fees, or costs to pay. Conditions: no law violations, no driving without a valid license, bench probation for 24 months. I am setting a mandatory review date for you, Mr. Campbell. That's going to be on December 19th, 2024. At that time, I'll be reviewing your progress with the work crew. If you have completed 10 days of work crew before then, that date can be excused, but check in with the court, okay? We're going to get you some documents, sir, at the desk by the door. Once you have your paperwork, go check in with the work crew chief. Thank you, sir.
Thank you, Your Honor.
Enough of that.
I have some matters that are ready yet.
Okay.
Is Joshua Alexander present over Zoom?
Maybe he's PDX-CADC.
Could be. If Mr. Alexander, if you're present, could you please unmute and turn on your video? I kind of anticipated him to be here from the treatment facility, but I'm not sure about that. Sent email to treatment facility regarding 19th, sent Zoom instructions. I can reach back out to the facility, Your Honor, or we can deal with it as we have a recent update. It's up to you.
Let's just keep going with what you have here right now.
Okay. Connor Garcia.
Okay. Is Mr. Garcia in the courtroom? There we go.
Yes, he's making his way forward, judge. Present out of custody. He's pursuing some relicensure stuff that we're just having to set this matter over to November, I think, with a waiver to that date. Client understands that he can't complain about having a jury trial within 90 days of the 21st of November based off the waiver.
Mr. Garcia, you're doing a waiver beginning November 21st that gives the city of Battleground in your case 90 days from that date if it becomes necessary to bring you to trial. Are you in agreement with that waiver?
Yes.
I'm going to accept the waiver. I'll find it knowing, intelligent, and voluntarily made. Your next court date, Mr. Garcia, is November 21st, 2024 at 10 a.m. Any previously imposed release conditions, including no driving without a valid license and insurance, do remain in place. We're going to get you some documents, sir, over at the desk by the door. Once you have your paperwork, you are free to go. Thank you.
Do me a favor and call me when you get relicensed.
Okay. Looks like we do have Mr. Alexander. I do see him up on the screen. Mr.
That's great.
Campbell, he was the PDX.
Great, Judge. We're ready to go on that matter then.
All right, Mr. Campbell, Mr. Alexander, I'm sorry, can you hear the court?
Yes, I can.
All right. Go ahead, Mr. Campbell.
Well, so Your Honor, we're still in a very favorable position as it relates to the client's treatment. So he's got various cases that are before your honor, post sentencing, and then some cases that are here, pre-trial, your honor. And now I see that I only have one cause number on this return to court, so I'm gonna need to fix that. But ultimately, he's doing very well. And so Joshua, you have a right to, I haven't spoken to him about this. I can go off docket if you'd like, Judge, but I think it might be
Talk
fast.
to him and see if he needs to talk to you.
You have a right to speedy trial, but because you're still doing so well in treatment, do you want to set over your case and waive your right to speedy trial out to December 19th to see where you're at as far as treatment goes? And then you can speak to me in private if you want to talk about that waiver before we move forward.
Actually, that sounds great.
You want to talk to me in private?
Just waive it to December 19th.
And so if that's sufficient for your honor, that's sufficient for me.
So, Mr. Alexander, you normally have 90 days when you're out of custody to be brought to trial. That can be 90 days from the first time you appeared in court. It could also be 90 days from your last waiver. What Mr. Campbell was proposing is that the waiver begin on the 21st of December or the 19th.
The 19th, Judge.
To begin on the 19th of December, that would give on the city of Richfield in all your cases 90 days from that date. It became necessary to bring you to trial. So do you understand that right to speedy trial?
Yes, I do.
And do you agree to waive that right?
Yes.
We'll accept the waivers. I'll find them knowing, intelligent, and voluntarily made. Sounds like the plan is to see Mr. Alexander back here in about 3 months on December 19th. Mr. Alexander, keep up the good work, sir.
Yep.
Right. Thank you.
Great job, Joshua.
Yep. Agreed.
I need Brandon has the documents still.
And sorry, Judge, I'm just.
That's all right. And Mr. Alexander, you certainly can go ahead and log out. Thank you for joining us from your facility, sir.
Thank you.
And if your honor will, I'll hand this up just so we can move forward, and then I'll get the file back from you afterwards so I can put all the case numbers on the speed trial. Okay. Also, these conditions on, I'll fill those up too if you're comfortable with that.
Yeah.
Yep.
That's all right.
Your honor, we have Molly Isaac.
Molly Isaac.
Molly, can you sign right there? This is that speedy trial waiver we already discussed. Your honor, this case I think is actually pretty well ready to resolve, but this is the first requested defense continuance. Ms. Isaac and I have some things that I'm hopeful to help her with between now and the set over in this matter. See what the release conditions were. No consumption, no driving. So we're asking for a waiver out to December 19th, 24 with a set over to that date.
So Ms. Isaac, if you do a waiver beginning on the 19th of December, that is saying that it's okay in this circumstance for the city of Richfield to bring you to trial within 90 days of that date. So 2 questions. Do you understand that right to speedy trial? And are you agreeing to enter that waiver of that right? When I accept the waiver, I'll find it knowing, intelligent, and voluntarily made. Ms. Isaac's next court date is going to be on December 19th, 2024. Previously imposed release conditions will remain in place. Ms. Isaac, please make sure that you are staying in touch with Mr. Campbell. We're going to get you some documents, ma'am, at the desk by the door. Once you have your paperwork, you are free to go. Thank you.
Can you call Tricia today and schedule an appointment? If you want it to be urgent, tell her that and she will take care of that. Okay?
Paperwork's going to be right over at the desk.
Right over there. The next matter we will call, your honor, is Shelby Vandenberg.
Shelby Vandenberg. Hello, ma'am. Can I have you state your name and date of birth, please, for the record?
Shelby Vandenberg, October 8th, 1991.
And is today indeed the 19th? I think I've been signing that the 20th all day, Judge.
I think those, they said the
It
19th,
is the
so.
19th.
Nope, that's my mistake. And both signed and executed agreement that dismiss this matter down to traffic infraction.
So Ms. Vanderberg, the original charge of driving while suspended third degree is being lowered to an infraction called failure to display a license. There are some associated costs. The total is $295. There's also a public defender recoupment. Do you agree that the infraction of failure to display a license took place?
Yes.
Okay. All right, I will find the infraction committed. We're gonna get you some documents, ma'am, at the desk by the door. Once you have those, you are free to go. Thank you.
That desk right over there at the table. And then I'm not sure if I need to take a brief pause for the clerks, but I've got another matter that's ready. Maxwell Stimson. Mr. Stimson is making his way forth, Your Honor. This is a case, where my client has a pending Superior Court matter. And so, we're asking to set it over out past the anticipated trial date for that felony matter. And then we will have a better idea of what we're going to be doing in this matter.
Mr. Stimson, in entering a waiver beginning on December 19th, 2024, you're giving the city of Battleground 90 days from that date if it became necessary to bring you to trial. Do you understand that right to speedy trial?
I do.
And are you agreeing to waive that right?
Yes.
We're going to see you next on December 19th, 2024 at 10 a.m. That is a mandatory court date. You can be here in person or on Zoom, but you need to be here. We're going to get you some paperwork at the desk by the door. Once you have your documents, you're free to go. Thank you.
Best of luck. We have, William Del Judas.
And Mr. Del Judas, if I can have you to state your name and date of birth for the record, please.
William Del Judas, 9880.
Mr. Del Judas, it looks like in your matter, the driving while suspended third degree is being amended to the infraction of failure to display a license. There is a fine of $145 and a filing fee of $150. Looks like there's also an agreement to mitigate a operating a vehicle without
Motor vehicle insurance, I think.
without insurance to $350. Do you agree that those infractions were committed, sir?
Yes, sir.
Give me just a moment. I'm gonna adjust the infraction here. All right, Mr. Del Judas, we're gonna get you some paperwork over at the desk by the door. Once you have your documentation, sir, you are free to go. Thank you.
Best of luck. We have, Antonio Guzman.
Antonio Guzman.
Your Honor, Mr. Guzman is present. He is out of custody and he's prepared to change plea today. And so handing forth a guilty plea statement right now. I'm going to fill out the judgment sentence as you're going through.
Is this the one that we need a?
Anti-harassment orders, do I need to recall it?
Yeah, this one will need a post-conviction
sorry.
anti-harassment order, not BV.
Back to just a
So,
second.
and
She's gotta
we do
be
have the
two pieces of
victim
paper.
present on
Are you ready?
Zoom, so let me fill that out first.
Okay. sounds
Sorry,
good.
Judge. I should have let Ms. Carmi know that we were going to be ready to go on that.
Okay.
So I will instead call Amanda Davis.
Okay.
This is,
Do I need to go back and get one?
no, I have this. It's the, when they change the forms, it's now a non-DV, no contact order.
I haven't seen that. I don't object.
Yeah, it is no DB tag on it.
Fine.
And it specifically will say this is not a DB on where the relationship, oh, no, they don't even put it in here.
Yeah, my own, and is that a form order? I'm sorry,
It's-
I'll talk about this on Ms. Davis, you're fine. Come on up. You can fill it out. I don't object.
And then I'll talk to you about it.
Yeah.
It's the same one in place pre-trial.
Okay. Oh. Ms. Davis, is also pending some felony matters, even in spite of her being declared otherwise resolved, she's being overly cautious and asking to set the matter over to that her felony case is resolved, and then we'll be ready to go on this case.
Looks like there's 2 cases today. Do you want me to add the other case number?
Please, and thank you. I'm so sorry.
It's all right. So Ms. Davis, on both of your cases, you have what's called a right to a speedy trial. What's proposed in front of the court on both cases, I'm just adding the second cause number, is to do a waiver of speedy trial that begins your speedy trial running again on the 19th of December. So my first question is, do you understand your right to speedy trial? And are you agreeing to waive that right with the beginning date being the 19th of December? I'm going to accept the waiver, find it knowing, intelligent, and voluntarily made. Ms. Davis, your next court date on both of your cause numbers, I'm just going to add the other one here as well. It's going to be on the 19th of December, 2024 at 10 o'clock in the morning. Please make sure that you are staying in touch with Mr. Campbell, okay? We're going to get you some paperwork, ma'am, over at the desk by the door. Once you have your documents, you are free to go. Thank you.
Call Tricia and let us know if your case resolves. Or if you call ready for trial. Thank you. And then we have Amber Moore, Your Honor. Amber, can you sign right here? Ms. Moore and I have previously discussed her right to speedy trial. This is another matter that's really close to resolving. It's a DUI offense of some note. And my client and I were only able to meet maybe a couple weeks ago, and some of the mitigating behaviors that we're hopeful she knew before we go forward with sentencing haven't been completed as of yet. And so we're asking for one set over before we resolve this matter, so the client can show some good faith efforts in regards to a likely plea, Your Honor.
Okay.
And I'm handing forth the documents associated with that.
So Ms. Moore, it looks like what is proposed is a waiver beginning on the 19th of December. That would give the city of Battleground on all 3 of your cause numbers 90 days from that date if it became necessary to bring you to trial. Do you understand that right to speedy trial?
No.
And are you agreeing with waiving that right? Yeah. And accept the waiver. I'll find it knowing, intelligent, and voluntarily made. I'm just going to add to the release conditions here to make them consistent with the last. Certainly, the ignition interlock condition remains in place.
Sorry, Judge, must have not
That's
noticed
fine.
that one.
Same with administrative release through Clark County pretrial release. And we're going to see you next on December 19th, 2024 at 10 a.m. Please make sure you are staying in touch with Mr. Campbell. We'll get you some documents, ma'am, at the desk by the door. Once you have the paperwork, you are free to go. Thank you.
Amber, you got it. Ms. Landwehr, can we get her a copy of the victim impact panel information? And do that before that next year. If you have any questions about it, let me know.
You can start on this, and I will hand this up in just a second.
And then Tony? It's not that we're ready to start the plea, and the rest of the paperwork will be your way. Perfect.
I didn't put this in there, but since he served 1 day.
Okay.
I just did 1 day.
So Mr. Guzman, the paperwork that I've been handed forward shows that the assault and the 4th degree charge is being amended to a charge called disorderly conduct, non-domestic violence. Have you had plenty of time to talk to Mr. Campbell about your case?
Yes.
Do you need any additional time? You are Antonio Guzman. You are 36 and you've completed some college. Is that correct? Are you able to read and understand the English language? In entering a plea today, you're giving up some important rights on your original charge of assault in the 4th degree. You have the right to a speedy and public trial by an impartial jury in a county where the crime is alleged to have been committed. You have the right to remain silent before and during trial and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you. You have the right at trial to testify and have witnesses testify for you, and witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty. And you have the right to appeal a finding of guilt after trial. You understand those rights, sir?
Yes.
You understand that in pleading guilty today, you're waiving or giving up those rights.
Yes.
The charge that you are pleading to is what is called a simple misdemeanor. It's subject to 90 days in jail and a $1,000 fine. There was a pretrial agreement that I'm holding up. Do you understand the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law?
Yes.
Court can place you on probation for 2 years, during which time you'd pay cost, fees, and assessments as authorized by law. To the charge of disorderly conduct taking place on March 29th, 2024 in the city of Battleground, Washington, how do you plead?
Guilty.
Are you entering the plea freely and voluntarily, sir?
Yes.
Has anyone made any threats or promises to get you to plead guilty?
No.
Factual basis states on or about March 29th, 2024 in the city of Battleground, Washington, I did use abusive language, thereby creating the risk of an assault. Is that a correct statement, sir?
Yes.
I will accept the plea. I'll find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. What's going to happen now, Mr. Guzman, is I'm going to hear briefly from the city attorney, Ms. Carmi. I'm going to hear from your attorney, Mr. Campbell, and you also will have the right to talk to me before I sentence you. Go ahead, Ms. Carmi.
Yes, Your Honor, we would ask you to follow the recommendation with the guilty plea. He does have 1 day credit for time served. The request from victim is to keep the no contact order that's been in place. So we have filled that out for a 5-year no contact order with the minor AKH. I will note the alleged victim is on Zoom. I don't know if he wants to be heard here at sentencing, but I just will point out to the court that he is here.
Let me ask if he wants to be heard, and then I'll go to you, Mr.
Thank you, Your Honor.
Campbell. Mr. Holt, did you want to say anything to the court, sir?
No, Your Honor, unless you need to hear from me, I have nothing to say.
Okay, thank you. Go ahead, Mr. Campbell.
You know, Your Honor, this is somewhat of a complicated situation. In many ways, it has stabilized. My understanding is my client and his wife, who co-owned this residence where the incident occurred, are pursuing a dissolution of their relationship. My client, at the time of the incident, was largely living up in Cowlitz because of some of the behaviors that were being allowed to happen in that home that he did not agree with, that I think many people in our community would not agree with. I'm not going to get into the particulars just because I don't necessarily have an interest in putting the victim's business out there, but there was a disagreement about what was being done in that house, and it was my client's house at the time, and he, believed he was within his rights to tell somebody to leave and to make them leave in the event they wouldn't do so. This is a reasonable middle ground. My client's got a limited criminal history. There's anti-harassment orders being put in place that protect the victim. And so we think it's a reasonable resolution. My client's also going to engage in an anger management workshop at his own cost, level 2, associated with this plea. So we just ask that Your Honor impose those conditions as outlined. Did you want to tell the judge? And then my client does not wish to speak, Your Honor. Thank you.
All right, Mr. Guzman, I will follow the recommendation of the parties. It'll be 90 days with 89 days suspended, leaving 1 day to serve. That day is to be served in custody with credit for 1 day served. I don't see the request for any fines, fees, or costs, so it'll be $1,000 with all thousands suspended. Bench probation for 24 months, no law violations, complete the anger management level 2 program. I am going to set a review date for December 19th, 2024 at 1:30. Certainly, if you've completed the anger management program before then, you've sent a copy to the court, we can go ahead and strike that court hearing, okay? We're gonna get you some paperwork, sir, over at the desk by the door, along with a copy of the anti-harassment order. Please make sure you understand this order and try to abide by it, okay?
Okay, so that course is online, you're gonna get paperwork about it. Okay. I would recommend getting that course done in like the next 2 weeks. I think it's 2 8-hour classes. So you do monthly or something like that. And get a certificate, send it into the court, make sure and call the court like a week beforehand to be sure that you confirm that you don't have to come to that hearing. Okay. But if you get that done, you don't have to come. Perfect. All right. Thank you, Judge. And then I have 2 more matters at least that are, one's really close to being ready, the other one's a little bit farther from being ready for both, or be ready here shortly.
Right. Couple of your files up here, Ms. Ward, when you're ready.
Your Honor, I have Dennis Smaga. Dennis, go ahead and come forward. And Your Honor, we have reached a resolution on this, but we just need a little bit more time to pull the paperwork together. We're asking for a short set over to October 3rd. He's done a waiver of speedy trial to accommodate that. We believe we'll be entering a resolution on that date, Your Honor.
Mr. Smaga, you've been able to talk to Ms. Ward about your right to speedy trial? And you're in agreement to enter that on the 3 cause numbers with a waiver of October 3rd. That would give the city of Battleground 90 days from that date if it becomes necessary to bring you to trial. You're in agreement with that?
Correct.
I'll accept the waiver. I'll find it knowing, intelligent, voluntarily made. Mr. Smaga's next court date is October 3rd at 10 o'clock in the morning. Please make sure, sir, that you are staying in touch with Ms. Ward. We're going to get you some documents at the desk by the door. Once you have your paperwork, you are free to go. Thank you.
So just the paperwork there and then I'll see you on October 3rd. Your Honor, I have Troy Owens. Troy, go ahead and come forward. Your Honor, similarly, we've just received an offer on this case that we are favorably disposed to. We anticipate accepting the offer. We're asking just to set that over to October 3rd. We've done a waiver of speedy trial to accommodate that.
Mr. Owens, in doing a waiver beginning the 3rd of October, you're giving the city of Battleground 90 days from that date if it becomes necessary to bring you to trial. Do you understand that right to speedy trial?
Yes, sir.
And you in agreement with the waiver? Yes, sir. We'll accept the waiver. I'll find it knowing, intelligent, and voluntarily made. We're going to see Mr. Owens back on October 3rd at 10 a.m. Please make sure, sir, you are staying in touch with Ms. Ward. A little bit of a backup over there at the by the door, but once you see that kind of clear out, you're going to get your paperwork over there and then free to go. Thank you.
Thanks, sir.
Thank you, Your Honor.
We do have some folks, just so everybody knows, on Zoom: Tanya Nelson, Vadim Dudko, Jason Sullivan, just in case so the attorneys know. Heard you guys had a pretty late docket last Thursday. Yeah, he reached out to Alex. That's a case that one of the cases is one that we also have part of it. And yeah. Yeah. Hmm. And we had a varsity football game last Friday in White Salmon. we left at 5, made it up there by about 6:30. We took 84 and it actually worked out. And then they had a home game on Monday, because we're doing now, because he's playing both varsity and JV. Yeah. He's not playing, I mean, he does kickoff team and the kick return team, but he's only one of the 2 kids that's been playing, so. But it means that when you say Longview, we're heading up to, he has a game at Mark Morris on Friday, so. Yeah. So. You get to go back, yeah.
Jill?
Yeah.
On the Madeline Stitman matter. Here is the PTA. Did you have any, do you have any preference on which case is dismissed?
No, not.
All right, perfect. I'm gonna just do the.
You want me to do? You want me to do?
You can do the dismissal if you don't mind. Let's go, you have a 3A case ending in 992. That looks to be the oldest one. Yes, ma'am. Thank you very much for that help. You're on probably 5 or 10 minutes before I'm ready to come back.
I'm gonna do the warrants now, Carol, if you have a breathing moment. The first matter that we called this morning several times is 4A07329891. That is Sarah Brown. I'm gonna be on Miss Carmi. I reviewed this. I didn't find probable cause based on what was in the file. This is the one where it seems that the female participant of eating the food is unidentified, and there was nothing in the file then that tied this person to that participant.
Yeah. There. That's without prejudice.
Okay. Okay, sounds good. Thank you. So on 4A0732-891, as I stated, the court wasn't unable to find probable cause. I have been handed forward a proposed order for dismissal without prejudice for further investigation. I am going to go ahead and sign off on that matter. So currently, there's not going to be a date set forward from Ms. Brown. Jason Folps is 4A0576-322. This is a July case that we had previously issued warrants for in August in the amount of $1,100. It looks like Mr. Folps came and quashed that warrant on the 5th of September and then proceeded to fail to appear again. I did call his name several times. On the Folps matter, do still have probable cause, and I'm just going to reinstate the warrant in the amount of $1,100. Final matter that I had on our 8:30 arraignment docket was Bolivar Islas Campos. This is cause number 4A0740-023. I did review the associated police reports in this case. I did find probable cause. Matter was scheduled for a court hearing Thursday, September 19th. I called the name several times. I have no one matching the name on Zoom. I am going to find that Mr. Islas Campos has failed to appear. I am going to authorize a warrant in the standard amount in the case. I reinstated the warrant that had been previously in place, and that was for 1,000. I think it's 1,100 or whatever that warrant is from August. We're just going to reinstate that warrant. Do we have any more in custody matters that we haven't gotten to yet?
Yeah. Yes.
Yes. No, it's totally fine.
Did you want to get done for today? You want me to come forward?
If you have matters ready, yes.
Yeah. You have Mr. Bowman Herrera.
All right, Mr. Monrero, it looks to me like I have a stay of proceedings. Were you able to review this document with Mr. Campbell?
Yes, Your Honor.
Do you have any questions about the document?
Yeah.
As I tell folks, I am not a party to these documents, meaning this is a contract specifically between yourself and the city of Richfield. My job is to make sure you understand the terms of the contract, and if you do the things you're supposed to do, that the charge is able to come off your record. This is a 6-month stay of proceedings. Your obligations during the stay will be to pay the following costs: $150 filing fee, $150 supervision fee, and a $300 public defender recoupment. That's a total cost of $600. You are to maintain a payment plan to make sure that that's paid. You are to do 2 days on the work crew program. As we talked about with folks, you must do at least 1 day of work crew every 30 days. The work crew chief is here right now, so when you finish with court, go to the same place you checked in for court and ask to talk to the work crew chief. You're not to drive without a valid license and insurance. You're not to have any new criminal charges. You're to make all your future court dates. You are giving up some important rights. You're giving up your right to a jury trial. You understand that, right? You're also doing a waiver of speedy trial beginning March 1st of 2025. Do you understand that, right, sir? The charge which you're entering your stay on is a gross misdemeanor subject to 364 days in jail and a $5,000 fine. We are going to set a return court date to monitor your work crew. That's going to be December 19th, 2024. Certainly also be checking in on the fine payments and so forth. If everything is accomplished on March 20th of 2025 at 1:30, your case will be dismissed. Do you have any questions for the court or for your attorney, Mr. Campbell, before I enter you into the stay? Okay. We are going to get you a copy of the stay paperwork, sir, at the desk by the door. Once you have your documents, again, go to the place you checked in for court and ask to speak to the work crew chief. Thank you, sir.
Awesome. Would you call me and let me know when you get it? Keep your head up. Keep doing the next right thing. Hey, you're right over there at that desk and she'll get your paperwork. And then we have Madeline Steitman, Your Honor.
Okay.
I think I'm saying that right. Did I say your name right?
You did.
Your Honor, I'm gonna hand one guilty statement. I have another one. I'm just finishing up in a couple. Judgment sentences. I'm prepared to enter a guilty plea on 2 similar cases. They're both for driving while suspended in the 3rd degree.
Do you have a PTA?
Sort of. What do I do with it? Yeah, it was just it was kind of a shorter form.
And we assumed full Blazina in addition to that email.
So Ms. Steitman, you are 25 and you've completed 2 years of college. Is that correct?
Yes.
Are you able to read and understand the English language?
Yes.
What is anticipated today is to enter a plea, it looks like, to 2 charges, dismiss 1, and then take no action on a probation violation. Is that your understanding?
Yes.
And is there a second set of statement of defendant on plea of guilty you're going to hand forward?
I am, Judge, and I actually
That's
realized
fine.
I need to have her sign that one as well when you're done doing the plea.
Okay. So, ma'am, in entering these pleas today, you're giving up some rights that we're going to review on the record. You have the right to a speedy and public trial on all your cases before an impartial jury in the county where the crimes alleged to have been committed. You have the right to remain silent before and during trial and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you. You have the right at trial to testify and have witnesses testify for you, and witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty. And you have the right to appeal the finding of guilt after trial. You understand those rights? Understand that in pleading guilty, you're waiving or giving up those rights. You have to say, okay, perfect. These charges have a maximum of 90 days in jail and a $1,000 fine. They're what's called simple misdemeanors. Do you understand that while there is a pretrial agreement that's been reached, the court does not follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law? To the charge of driving while suspended third degree taking place on June 29th, 2023, in the city of Battleground, Washington, how do you plead?
Guilty.
Are you entering this plea freely and voluntarily?
Yes.
Has anyone made any threats or promises to get you to plead guilty? Factual basis states on or about June 29th, 2023, I did operate a motor vehicle with notice and while suspended to my privilege to drive in the third degree in the city of Battleground, Washington. Is that a correct statement?
Yes.
I will accept the plea. I'll find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. The second part of your plea, Ms. Steitman, is going to be, again, to the same charge. We've already gone through your rights. Would you like me to reread the rights for you at all?
No.
Okay. So the factual basis for this charge is going to be on December 3rd, driving while in third degree, that on June 22nd, 2024 in the city of Battleground, Washington, how do you plead to the charge of driving while suspended in the third degree?
Guilty.
Are you entering this plea freely and voluntarily?
Yes.
Anyone made any threats or promises to have you plead guilty in this charge? Again, factual basis states on or about June 22nd, 2024 in the city of Battleground, Washington, I did operate a motor vehicle while suspended in the third degree. Is that a correct statement?
Yes.
Will accept the plea to that charge, find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. Let's find homes for all this stuff first.
Just now that I think about it, do you need a review hearing form for the 3A case?
I'm looking, I think the case number written on this plea agreement is incorrect. But
Oh, my apologies.
let me just see. Yeah, it looks like this is probably the one. This is 992.
Which one are we looking at, Jeff?
So this one is, it says 3A043536. I think it's 366.
Yeah.
366 should be, that's, if I wrote that wrong, I greatly apologize.
That's okay. Just making sure. I was trying to figure out what's going where. Okay, Ms. Carmy, anything from the city?
Just to follow the recommendation, I think Ms. Steitman is, she doesn't have much to do to get reinstated, but I think in lieu of pushing all of these cases forward for more time, she's choosing to take this guilty plea and then work on reinstatement. So we would ask you to follow the recommendation.
Just to make our record clear, on 3A05109992, there is a dismissal with prejudice. So I have entered the dismissal and signed off on that. The agreement from the parties is on XZ004971 that no violation be filed in that case. Mr. Campbell, do you want to be heard on the pleas on either the 4A or the 3A case that we have still before the court?
Please and thank you, Judge. You know, this is a little bit of an exceptional situation. My client's only 25. When I got these files, I was a little curious, just to be honest with you, how it could be that we got to this point. I mean, she did 3 days jail. She went a period of time without having an ability to drive a motor vehicle lawfully and seemed to, even after a few law enforcement contacts, which for a young person might kind of jog their attention to a matter, didn't take note of those aspects and is here today taking responsibility for it after going out on warrants. What I identified and kind of coming up with a plan with my client is that she does have a mental health diagnosis that hasn't been being really addressed, as well as some significant other things in her life that she needs some support with. I'm not going to get into them in detail just out of respect to my client, but I think that the things that she's dealing with, particularly with a young mind, create a situation that doesn't really allow a young person the best opportunity to process pros and cons. So she's taking affirmative action to address those concerns. And certainly, the 3 days jail that she has done, she has credit for time served for 3 days in this case.
And do we know which case has how much jail on it?
I do not.
I'm assuming maybe the 3A case has 1 and the 4A case has 2.
Yep,
But
I'll look right now.
I was going to just defer to your honor to put it where you have found appropriate. Defense isn't too.
What's the state of her finances?
Are you working currently? Let me look at the finances, Judge. I have them right here. She's not working currently, and just with her unaddressed mental health concerns, your honor, I would ask you to find her indigent and incapable of reasonably making fines and fee payments right now. Are you getting federal or state assistance like food stamps or anything like that? Are you living with your parents? She does live with her parents, your honor, and isn't getting state or federal assistance because of that, but she's really not capable of work currently and needs to address some of these underlying concerns before probably doing that.
Ms. Stiteman, is there anything you'd like me to know? Right.
And Your Honor, it looks like all 3 days were done on the 4A.
Okay.
At least according to our records.
Okay. All right, so on 3A0435-366, 90 days with 90 days suspended, $1,000 fine with all thousands suspended. I'm going to find pursuant Blazina analysis. Ms. Stiteman is indigent. Probation, no law violations, bench probation for 24 months. I'm not going to assign any conditions, no review dates. On 4A0517-436, 90 days with 87 days suspended, 3 days to serve in custody with credit time served for 3 days. $1,000 fine with all thousands suspended. Again, bench probation for 24 months, no law violations, no driving without a valid license and insurance. I'm going to add that to 3A. Again, I didn't state it already, pursuant to Blazina analysis, I'm going to find that Ms. Stiteman is indigent. I'm not going to impose any fines, fees, or costs. Again, not going to assign any return dates. So, ma'am, that concludes your hearings. As Mr. Campbell stated, it seems like you're within striking distance of getting your license back. The only way that this gets fixed, though, is if you don't drive until that completely is done. Okay? All right, ma'am, we're going to get you some documents over at the desk by the door. Once you have your paperwork, you are free to go.
This is just for the on the XE matter, if your honor wanted.
Yeah, thank you.
Okay, madam, right over there. Keep it up. You don't want to do it once this morning's docket. I can go get my files and see if I have any information to share.
You do have some folks that are still on Zoom.
And Tanya Nelson.
Ms. Ward?
Sure, I have a couple matters I have on Zoom. The first one is Jason Stevens,
Jason Sullivan, maybe?
or Jason Sullivan, I'm sorry.
It's okay. Mr. Sullivan, if I
Same
could have
initials.
you take yourself off of mute, turn your camera on, please, sir. Thank you, sir. Can I have you state your name and date of birth, please, for the record?
Yeah, Jason Sullivan, May 20th, 1975.
Okay, your attorney, Ms. Ward, is with us here in court. Go ahead, Ms. Ward.
Yes, Your Honor. This is on for an SR violation. Your Honor, at this time, we're going to be denying the SR violation and asking to simply set it forward to track with the defendant's next court date. The SR violation basically was that he had failed to install a scram monitor. He went in on September 6th, had some difficulties with installing that because they couldn't zero it out. He had used some hand sanitizer. However, they were able to subsequently install the scram monitor last Thursday on September 12th. And to my knowledge, he has been in compliance since that date.
Do we have proof of that compliance? I only have the indication they couldn't put it on. I don't have the follow-up that it's on now.
I can show you on the camera.
Yeah, and the only thing they sent us was the September 6th notice that they weren't able to do it. That's the most recent thing I have.
So Mr. Sullivan, do you have a scram monitor on now, sir?
Yes, do you want me to show it to you?
No. And so when Mr. Sullivan is next scheduled for, we had him on September 5th. When is his date forward? Or looks like it's September 19th, which is today. So
And Your Honor, we are still in the process of negotiating with the prosecutor at this point. I thought that we had an October date. I apologize, I don't have that date in front of me. If we don't have a date set, I would ask that we set this out into the future to maybe the October 3rd date. That would be well within speedy trial. If we're unable to reach a resolution by that date, we could certainly set out further if necessary.
any objection to sending this to October 3rd, Ms. Carmi?
No objection, Your Honor.
All right, Mr. Sullivan, Ms. Ward, if you could do I could do a return to court. So, Mr. Sullivan, what's proposed is that your next court date will be October 3rd, 2024. That will be at 10 a.m. You can be in person or on Zoom, but you need to be present in some way, shape, or form on that day.
Sure.
Release conditions do remain in place. I'm not sure why I had marked the interlock box on this case, but it seems that he's suspended, so I'm assuming scram. But that's ordered through district court. But they must think that we have it as well if they're sending us the violation. But I'm going to go ahead and just mark that box. It seems that Mr. Sullivan is complying with that condition. From our court paperwork, he is on intensive pretrial release as well, and that one is marked correctly. So, Mr. Sullivan, the court's going to be mailing you some paperwork. We have an address for you, sir, on 9th Street in Vancouver. Is that the address you're getting your mail at?
Yes, correct.
All right, we'll be sending your mail there. Again, we're going to see you back here October 3rd at 10 a.m. Please make sure you're staying in touch with Ms. Ward.
Okay, thank you, Your Honor.
Thank you, sir.
Yep.
Your Honor, I have a Sophia Caldall. She is on Zoom.
Okay, Sophia. Sophia Caldall.
That's correct, Your Honor. It's going to be an entry of a stay.
Hello, ma'am. Can you state your name and date of birth, please, for the record?
Sophia Caldall, July 26th.
Ms. Caldall, it looks like you're entering a stay of proceedings today. This is a contract between yourself and the city of Battleground. Have you been able to talk about this agreement with your defense attorney?
Yes.
Do you need any additional time, ma'am?
No.
All right, we're going to review it on the record together. There are some fines, fees, and costs. There's a $150 filing fee, $150 supervision fee, and a $300 public defender recoupment. So that's total costs of $600. You are to maintain a payment plan to accomplish that. You are to do 40 hours of alternative community service. You're to get documentation to the court in regards to whatever nonprofit you choose to do that community service at. You're to do the anger workshop level 2, which is online. You're not to have any contact with Ivy Nyberg. That's just a formal no contact order now. No law violations, good behavior, appear at all future court dates. You are giving up some important rights. These are not initialed, Ms. Ward. Have you been able to go over with Ms. Caldwell?
I have, Your Honor. I read to her. She is residing out of town, out of state. And so I did over the phone read her line by line.
Ms. Caldwell, do you understand your right? You're giving up your right to a jury trial?
Yeah. Yes.
Are you in agreement with that, ma'am?
Yes.
Do I have your permission to add your initials to that part of the form?
Yes.
All right, I've written SK, permission via Zoom. Today's date, 9/19/24, and my initials. You're also doing a waiver of speedy trial. Do you understand that right to speedy trial, ma'am?
Yes.
And you're in agreement with entering a waiver that starts a year from now on September 19th, 2025.
Yes.
Do I have your permission to add your initials to this portion of the form?
Yes.
Again, I've written SK, permission via Zoom, and today's date, 9/19/24, my initials. The charges you're entering your stay on is a gross misdemeanor. It's subject to 364 days in jail and a $5,000 fine. The signature portions on the form are also empty. Do you have any questions for Ms. Ward or the court about the stay of proceedings?
No, I do not.
Do I have permission to write your name on the stay agreement?
Yes.
I am printing this. I'm writing Sophia F, Caldwell, and noting permission via Zoom, 9/19/24, and my initials. I'm also on the order printing the name Sophia F. Caldwell. Permission via Zoom, 9/19/24, and again, initials. Ms. Caldwell, we're going to see you next on December 19th, 2024. That's an appearance that can be over Zoom. At that time, we'll be looking into your alternative community service along with your anger workshop level 2. A final court date will take place on September 18th, 2025. And at that time, if you've completed your conditions, your case will be dismissed. Do you have any questions at all about your stay agreement, ma'am?
No, I do not.
We're going to be mailing you some paperwork. Are you getting your mail on Parsons Street Southwest in Atlanta, Georgia?
No, I had to call the clerk's office after I'm able to move into my new place. For a mailing address.
Is there an email address we can send paperwork to in the meantime?
Yeah, it's my first name and last name at gmail.com.
Okay. So it's Sophia Caldwell. No dots, dashes, or anything like that?
No.
At gmail.com. Okay, we'll send your documents there, ma'am. Thank you very much.
Thank you. Oh, I get off this. Sorry, hold on. I don't know how to get off this. My phone's a little bit broke.
Word.
Here I have Humberto Guzman Cesarez, who's here in court. This is going to be an entry of a plea of guilty to amended charges. Count 1 is going to be amended to a reckless driving, Your Honor. Count 2 is being amended to a driving while suspended in the 3rd degree.
Mr. Guzman Cazares, you are 45 and you've completed the 12th grade of school. Is that correct?
Correct.
Are you able to read and understand the English language?
Correct.
Okay. And entering a plea today to a charge of reckless driving and driving while suspended 3rd degree, you're giving up some important rights that were originally associated with your DUI and your DWS2. We're going to review those on the record. You have the right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed. You have the right to remain silent before and during trial and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you. You have the right at trial to testify and have witnesses testify for you, and witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty. And you have the right to appeal a finding of guilt after trial. Do you understand those rights?
Yes.
And you understand that in pleading guilty, you're waiving or giving up those rights. The charges which you are pleading to, one is what is called a gross misdemeanor. It's subject to 364 days in jail and a $5,000 fine. Yeah, there's a simple misdemeanor subject to 90 days in jail and a $1,000 fine. There is a pretrial agreement that I'm holding up. Do you understand the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law?
Right.
Court can place you on probation for a time frame of 2 years, during which time you'd pay cost, fees, and assessments as authorized by law. Box J in your plea paperwork is checked, indicating a mandatory 30-day license suspension. You understand the court cannot choose not to impose this suspension as required by statute.
Yes.
So my question, Ms. Ward, about box R or area R, does he have a previous DUI within 7 years?
He doesn't, Your Honor. I apologize. That may have been marked by mistake. I just simply was indicating that he understands that if he were to get another DUI within the 7-year period of time, that this would count as a prior for purposes of moving forward.
Yeah, the reason that I would say we don't want to have that box checked, it can add 6 more months of interlock.
And-
So I'm going to cross that out and initial next to it.
And I apologize, Your Honor.
It's okay.
I checked it in error.
Not a problem. So to, Sir, Mr. Guzman Cazares, to the charge of reckless driving taking place on June 3rd, 2024 in the city of Battleground, Washington, how do you plead?
Yes.
The charge of driving while suspended in the 3rd degree on the same date and location, how do you plead?
Yes.
Are you entering these pleas, sir, freely and voluntarily?
Yes.
Has anyone made any threats or promises to get you to plead guilty? The factual basis for the charges state on or about June 3rd, 2024 in the city of Battleground, state of Washington. I operated a motor vehicle with a willful and wanton disregard for the safety of persons or property, and while my license was revoked or suspended in the 3rd degree. Are those correct statements, sir?
Correct.
I will accept the pleas. I'll find them knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. What's going to happen now, sir, is I'm briefly going to hear from our city attorney, Ms. Carmy. I'm then going to hear from your attorney, Ms. Ward, and you'll also have the right to talk to me before sentencing. Go ahead, Ms. Carmy.
Yes, Your Honor, just in the interest of time, I would ask the court to follow the recommendation. I'll defer to defense on closing that.
And Your Honor, we would similarly ask the court to follow the recommendation. We think it's fair and appropriate under the circumstances, but for the financial portions, we would ask the court not to impose any additional financial obligations. My client's been working in construction, but he hasn't worked for about 5 to 6 months because he hasn't been able to afford the bond or insurance in order to continue working. He's supporting his son on what income he does have, and he's behind rent about 3 months. He just recently went through a divorce, so is experiencing costs associated with that. Any additional costs are going to be very difficult for him to be able to make, Your Honor.
Sir, anything you'd like the court to know?
No, that's about it.
All right, I will follow the recommendation of the parties to count 1, 364 days in jail with 354 days suspended, leaving 10 days to serve on work group. It'll be a $5,000 fine with all 5,000 suspended pursuant to the Blazina analysis. I'm going to find that Mr. Guzman Cazares is indigent. Count 2, 90 days with 85 days suspended, 5 days to serve on work crew. The work crew sanctions are to run consecutive to one another, so it's a total of 15 days of work crew. $1,000 fine with all 1,000 suspended. Work crew, sir, must be done at least once every 30 days. More than 30 days pass and you've not done work crew, it does get returned to me. The work crew chief is here right now. If you go to the place you checked in for court, ask to speak to the work crew chief, he can get you signed up for that. Other conditions on the case: substance use disorder evaluation and comply with recommended treatment. Victims impact panel. We're going to review, sir. You're placed on bench probation for 24 months. We're going to review those conditions along with your work crew at a hearing that's going to take place on the 19th of December at 1:30. That is a mandatory court date. At that time, we'll be looking at the work crew, the substance use disorder evaluation, the recommended treatment, and the victims panel. Please make sure to provide your documents to the court prior to that date. We're going to get you some documents, sir, at the desk by the door. Once you have your paperwork, go check in with the work group chief.
Thank you, Your Honor.
Thank you.
Your Honor, I need just
We're back on record in case ending in 67 with Mr. Allgood. Mr. Allgood, did you complete that waiver of attorney form?
Yes, I did.
And did you sign the bottom of the form?
Yes, Your Honor.
Do you have any questions about your right to a defense attorney?
No.
You understand that waiver of a defense attorney means you're giving up your right to a defense attorney?
Yes.
You understand when you give up your right to a defense attorney, you'll be acting as your own attorney in this case?
Mm-hmm.
And is that yes?
Yes. Yes, Your Honor.
And, all right. And it's your decision to do that for reading the advice in that form. Is that true?
Yes, Your Honor.
All right. The court accepts your waiver of attorney. Go ahead and take that form and slide it under the door behind you there, and I'll have the jail personnel send it over to me. Mr. Allgood has done as he was instructed. Mr. Allgood, just because you waived your right to an attorney doesn't mean you've waived your right to a fact-finding hearing. You can still request to have a bond be set and to have a fact-finding hearing. Do you understand that?
Yes, Your Honor.
But do you understand that if you admit the allegations in the petition, then you waive or give up your right to a fact-finding hearing? Do you understand that?
Yes, Your Honor.
All right. Any other questions for me?
No.
Do you admit or deny the allegations in violation of informal probation petition?
Yes.
Yes, you admit them?
Wait, what'd you say?
I'm asking whether or not you admit that you violated probation by not getting your driver's license in 30 days and not paying the fines and court costs.
Yes, I did.
Okay. Then is there anything you want me to know about the reason why those things didn't occur?
So I currently moved into a house of 220 North 12th Street. And I didn't have 2 pieces of mail. Every time I went to the B&B, they told me I had to get 2 pieces of mail. And so I was trying to get that 2 pieces of mail and I couldn't get it. So therefore I couldn't take the driver's test to get my driver's license.
And that was 220 North 12th Street here in Decatur?
No, Richmond, Indiana.
Oh, that was in Richmond. So then since then you moved to 419 Commerce Road, room 408?
Yes. Yes.
All right. And why haven't you paid the fines and court costs?
Because I have a baby on the way, and I've been taking care of my baby mama. I also have to take care of my mom, which I was working at Wendy's, getting paid. They was messing up my pay. They wouldn't let me see my pay stubs or nothing. So I don't know how much I was getting paid. I had a pay card and I was getting paid on a Paycor app. And they wouldn't let me see my pay stubs. I was making like $300 every 2 weeks.
Who else lives in the the hotel with you?
My mom and dad.
And that's the one on Commerce Road, right?
Yes.
Do you have any money in the bank or cash on hand?
No, I do not. I have nothing on me.
You have nothing on you? Okay. And other than at Wendy's, are you still employed at Wendy's?
No, I am not.
Do you have any other job?
Before I came here, I was supposed to, work through a temp agency, making $19 an hour. But I, came here.
All right. Anything else you'd like me to know?
I was trying my hardest to get my license. It's a short span within that time in the, mailing that, I have to get. So, yeah, that's all I really can say. It was a, short span.
Mr. Thurston?
Judge, given the nature of the charge and based on his admission today, the state would recommend revoking the 4 actual or 8 sentence days to which he has already spent on this, unsatisfactorily discharging him from probation and reducing his fines, fees, and costs to a judgment.
Mr. Allgood, do you understand what he just said?
No, I don't understand.
Mr. Allgood, you've already spent 4 actual days in jail. And so what he's saying is he's asking that I revoke 4 actual days and then grant you 4 days of credit, which means that would be a time served sentence that you'd be released today, that you would be terminated from probation as unsuccessful. So if you're ever on probation again, or if you ever get a criminal case again, then the court and the prosecutor might look at that and say, look, Mr. Allgood is not a good candidate for probation because he failed to successfully complete probation this last time. And then also that that $314.50 and fines and costs, that be reduced to a judgment, which means then a collection agency would eventually be, you'd still owe that amount and they would be the one trying to get you to pay that amount. Does that make sense?
Okay, yes, Your Honor.
You have anything you want to add to that?
No.
All right, that's what the court's order is going to be, is 4 actual days of incarceration, 4 actual days of credit, time served, and the fines, fees, and costs to the court are going to be reduced to a judgment. This hearing is concluded. You'll be released today, Mr. Allgood, okay?
Okay, thank you.
You're welcome. This hearing is concluded. That's all.